Good afternoon to all our esteemed panelists, faculty, and all the attendees present here. I would like to extend a very warm welcome to all of you on behalf of the GNLU Center for Law and Economics to the second GNLU workshop on research in law and economics. Without any further ado, I would like to first call upon our director, sir, Professor Dr. S. Shantakumar, National Law University, to present his welcome address at the inauguration session.
Thank you. Distinguished. Am I audible?
Yes, sir. Yes, sir.
Yeah.
Yes, sir.
Thank you. Thank you so much. Distinguished Dean Academics, Professor Dr. Mamta Biswa, distinguished Head of the Center for Law and Economics, Professor Dr. Anita Nagar, Convener of the workshop, Dr. Hitesh Thakur, the other research colleagues in the Center for Law and Economics, distinguished participants. I extend a very warm welcome to each one of you to this workshop on law and research in law and economics. So greetings from Gujarat National Law University. The science of economics is concerned with the problem of distributing the limited energies and natural resources at the disposal of man to satisfy his unlimited wants as far as possible. All the wants of all persons can never be satisfied, but we shall consider that the economic optimum has been attained when it is impossible to transfer any of the natural resources and human energies from the satisfaction of one want to the satisfaction of some other want without decreasing the total satisfaction obtained from the use of the given amount of energy and natural resources. In order to solve this problem rigorously and realistically, we should need to know the natural resources of the economy, the size and characteristics of the population, the private property of each individual, wants of each person and their order of preference, the state of technical knowledge, and the institutional framework within which the economic activities of the population are to be executed. The economic system must be adapted to changing conditions and must incorporate new ideas if it is to attain the highest possible efficiency. It follows that its institutions must play an important part in this adaptation, and that new laws must be made or old laws must be modified in the light of new developments. Old laws may hamper the introduction of new ideas and methods of production, which would result in definite improvements in economic efficiency. For example, the introduction of selling products on EMIs. The introduction of selling products on installments has revolutionized the sale of expensive durable goods. The consumer has been enabled to enjoy the fruits of his savings during the long period required for him to accumulate them. So the production of such durable goods have been stimulated far beyond the level which could have been attained had the consumer had to save his capital before the purchase could be made. houses, cars, even mobile phones and computers have been produced on a much greater scale, largely because of the new idea of selling it on EMIs. In addition to saving, a necessary concomitant of increased production has been stimulated by the possibility of higher purchase. The introduction of selling through EMIs meant, however, that a body of law was required to establish it on a workable basis and to protect it. So the body of law in existence before the introduction of selling through EMIs has proved sufficient for the new idea to work. But it was only recently that the problem of adapting the law to the requirements of selling through EMIs was tackled in a scientific manner. If the full benefits of technical and economic progress are to be reaped, a quickly adaptable legal system is a necessity. I am reminded of what Justice Oliver Wendell Holmes of the American Supreme Court said long back in 1897. I quote Justice Holmes. He says that for the rational study of the law, the black letter man may be the man of the present, but the man of the future is the man of statistics and a master of economics. We learned that for everything we have to give up something else, and we are taught to set the advantage we gain against the other advantage we lose, and to know what we are doing when we elect. So what more I can say about the importance of these two disciplines coming together, more than better than Justice Holmes. One can very easily find that the law and the economy interact in many ways. Whereas private law assists individuals and groups who are willing to enter into agreements in a free market, public law seeks to correct the outcomes of a free market system by means of economic and social regulation. Economists themselves should be informed about the legal environment in which economic activities must be conducted, while lawyers should be aware of the economic effects of current legal rules and the expected outcome under a different legal regime. In fact, law and economics measures together two of society's fundamental social constructs into one subject, allowing a multifaceted study of significant problems which exist in each subject. Law and economics, with its positive economic analysis, seeks to explain the behavior of legislators, prosecutors, judges, the bureaucrats. The model of rational choice, which underlies much of modern economics, proved to be very useful for explaining and predicting how people behave under various legal constraints. This positive analysis actually informs the normative branch of the discipline and possible outcomes. If effects of divergent legal rules and institutions are known, the normative analyst will be able to discern efficient rules from those that are inefficient and formulate reform proposals to increase the efficiency of the law. Also, law and economics has the ability to improve the quality of the legal system. In the last decades, an impressive literature has developed showing the strength of both positive and normative economic analysis in various areas of law. I wish to quote Judge Richard A. Posner, who said that, I quote, "To me, the most interesting aspect of the law and economics movement has been its aspiration to place the study of law on a scientific basis with coherent theory, precise hypothesis deduced from the theory, and empirical tests of the hypothesis. Law is a social institution of enormous antiquity and importance, and I can see no reason why it should not be amenable to scientific study. And economics is the most advanced of the social sciences, and the legal system contains many parallels to and overlaps with the systems that economists have studied successfully. In fact, law and economics began its synthesis as a discipline through the theories of the Chicago School and received guidance and influence from pioneers like Calabresi and Nobel Prize winners like Ronald Coase and Gary Becker. In fact, Judge Richard Posner's book on economic analysis of law became one of the classics of the discipline. Recently, other methods have moved to the fore, including the property rights approach, the Austrian school, and the neo-institutionalist approach. In spite of these developments, it is difficult to understand why, although the lawyer finds a certain knowledge of economics indispensable, and the practical economist finds a certain knowledge of the law equally valuable, the relationship between law and economics has never been given the consideration it deserves. The economic cost of any ethical or strategical advantages of proposed legislation must be very carefully estimated before the law can even be considered, and the lawyer must then perform the function of blending the requirements of the economic system with the social and ethical requirements of the day. To do this, he must have a clear knowledge of the effects of this or that restriction upon the economy. His economics must be impeccable. Either we are to require some such lawyer economist to prepare the law, or there must be some machinery whereby the lawyer on the one hand and the economist on the other can collaborate in the elaboration of law. It is only then that the economic ends and the ethical ends of society shall be reconciled. Economists and lawyers can also learn techniques from each other. From economists, lawyers can learn quantitative reasoning for making theories and doing empirical research. From lawyers, economists can learn to persuade ordinary people, an art that lawyers continually practice and refine. To benefit from each other, lawyers must learn some economics and economists must learn some law. So the law and economics movement applies economic theory and method to the practice of law. It asserts that the tools of economic reasoning offer the best possibility for justified and consistent legal practice. The law and economics movement offers a general theory of law as well as conceptual tools for the clarification and improvement of its practices. The general theory is that law is best viewed as a social tool that promotes economic efficiency, that economic analysis and efficiency as an ideal can guide legal practice. It also considers how legislation should be used to improve market conditions. Law and economics offer a framework with which to model legal outcomes and common objectives with which to unify disparate areas of legal activity. The bringing together of legal theory and economic reasoning has also created a new research agendas in the field of behavioral economics. How rationality affects people's behavior within legal scenarios. Public choice theory and how collective behavior should have an effect on legislation. Understanding strategic action in a legal context. This is such an interesting and wonderful area for research, and therefore my sincere appreciations to the Center for Law and Economics, especially to its head, Professor Anita Nagar, for conceiving this idea of conducting this workshop on research in law and economics. I'm sure that this workshop will provide adequate opportunity for the participants to understand the nuances of research in topics involving both these disciplines, law and economics, and to apply it in their research work, which they are already doing it or which they intend to do, and for publishing it in quality journals. I wish this workshop a grand success, and I thank the organizers for giving me this opportunity to speak on this. Thank you so much. Wish you all the best.
Thank you very much, sir.
Thank you so much, sir, for your words. I'm sure everyone here is quite grateful for your presence. Now, I would like to call upon Professor Dr. Mamta Biswal, the Dean for Academic and Faculty.
Khushi, there was some interruption. Could you please introduce Madam again?
Yes, ma'am, sure. Thank you so much, sir. Now, I would like to call upon Professor Dr. Mamta Biswal, the Dean for Academic Faculty Affairs at Gujarat National Law University, for her address.
Thank you, Khushi. Can you hear me, Khushi?
Yes, ma'am.
Honorable Director, Professor S. Santakumar, sir, the center head, my colleague, Professor Dr. Anita Nagar, the member of the center, Dr. Hitesh Thakur, and the TRA student members and the participants. First of all, I congratulate the center and my colleague and friend, Dr. Nagar and Dr. Hitesh, for organizing such a wonderful workshop. Already our director sir has told that this is a very unique program to learn the research uh, idea how to do research in law and economics, and he spoke about very high level conceptual aspects relating to this. So just to start about this workshop, again I also support our director sir that really it is a very unique program that we do. We know the general research methodology, how to do a research, how to test the hypothesis. But the very interesting point in this workshop is that how to do research in law and economics, how to bring both these subjects together. And where there are so many academic views, agreements, disagreements are there. So again, I repeat few points told by our director sir, like positive theory and normative theory. So when we go for the research, two things that the legal efficiency of that particular law, that how well the law is implemented, that is still the law according to my belief. Next part is how that implementation of law can be extended to the economic benefit of the people, market, etc., etc. That is what I understand in a layman language, law and economics, why we should bring together. Many times I discuss with madam various subject. One day this example came that in a matter of tertius liability, tort law, one side we see that the unliquidated damage is the very important element in tort. That is the charm of tort, that in a private wrong we can claim the compensation which is not fixed. In a contract it is fixed, in other matters it is fixed. But in law of torts, one can go to any extent one can reduce also. Like in the McDonald case where a lady, 65-year-old lady, who just had the third grade burn injury, but she was awarded $1 million for as compensation. And that is the charm of tort law, that duty of care, proximity, and the other elements. So at the same time, when we go for this analysis of the law through the lens of economic theories, this point comes that it is rather to provide an incentive for this for the protection, or to take efficient step to avoid the such kind of accident or negligence in future. So that in this, just it is an example, because I thought to understand this through a very simple example, and law of torts everybody has studied. So one side compensation, which is the core principle of tort law, that unliquidated damage. It can be 10,000 in a matter. Same fact, it can be $10 million also. And that is why the club torts is very famous in the other countries, USA, UK. It is not very developed in India. But at the same time, when we look through the this economic analysis, that yes, it is an incentive to avoid the future accident, negligence, etc. So that when I think that only compensation, then yes, it is only one part. When we think the incentive, maybe the combination of both can be better for the society. That is what I think, law and economics. So here you give compensation, there you stop the such kind of behavior of the people in future. So what else better can be there? That is my understanding. So it is one example. If I go for every subject, property law, constitutional law, then very simple example today I was thinking after I received the link, maintenance law, which is one of the very prominent area, and where really the one side we say that it is a economic right to the married, the women, the parents, according to the law, Adoption and Maintenance Act, parents, children, etc., etc. 125 CRPC, the married woman who is neglected. So that in that area, sometimes it I feel that yes, maintenance is one of the economic right which has been derived from the law. But at the same time, the when we see through the multiple laws, like here you have 125 CRPC, there you have your personal laws. Then the issues where the which law will prevail over which law. So in this area, I think a very good research can help the country, that how this economic right can be extended to all, irrespective of the religion or age or anything. Generally, religion is one of the barrier here, because when we say 125 CRPC, then it is applicable to all. But at the same time, after the Sahabano judgment, Daniel Latifi, Lily Thomas, the issue is that when the specific law by the Muslim law board came and it was enacted, now the situation is that if a Muslim woman applies for the maintenance under section 125 CRPC, then that personal law also will be considered. It is not completely considerable like the previous days prior to Sahavano case. But at the same time, these conflicts are there. So here, if a research can be done with the combination of law and economics, and this particular economic right, which is one of the very, very necessity of the neglected women in India, it can be extended to them equally. So same thing when I come to succession law. the property right of a female in India. Same thing that in Hindu Succession Act, you get a different right. Then you go for the ancestral property right, like the undivided Hindu family property. There she gets a different right. Then same thing in the Christianity, you get a different right. In Muslim law, you get a different right. In Parsis. So that why a very thorough research should not be done in this area, and a very good solution can be brought, and the country will be very helpful by this. That yes, the very important economic right of the females in India is protected through this research of law and economics. So what I am trying to tell is that there are many identified area, and telling these examples is that first a researcher should think that in which area really we can apply both in micro and macroeconomics. But first is identification of area, and according to me, these are few area like in criminal law. When I see the children's, the poor children's, when they commit the offense, and sometimes they get the protection, then because of the age factor, when they don't get the protection, there we can also see that what is the reason. Many times I see that lack of education and the poverty is one of the factor. So there can't we add certain law that which can help these people, these children, that they will get proper education, they will get proper maintenance, irrespective of the fact whether their parents are alive or they are rich or they are poor. But children can get some protection where this number of crimes can be reduced. That is what I read somewhere, and I also feel if the if we see the background of the many criminals, will see many times they commit the offense without knowing the law. They do not know that if it is 302, then life imprisonment is there. Where it is written in IPC, they do not know. Somebody tells them, then they do, then they get punishment, and the entire life is gone. So can't we do some research where such kind of socially beneficial suggestions can be given to the government, and the law can be changed accordingly under the lens of this research of law and economics. So that these are few points I wanted to tell you, and this is just an inauguration, and I am very much afraid when I saw the list of the resource person, and our opening batsman, Santa Kumar sir, and then madam is there, Ranita madam. I am very much afraid because I am a layman in this area, but slowly listening from others, and as a law person, my experience when I travel, I see the children, the poor people, lady struggling for maintenance. The husband dies, then lady struggling for the ancestral property. So many social issues are there connected to the law, and where this research in law and economics really can help the people, the country, and also the academics and practitioner. So this is just a very small introduction about in my experience, limited experience, I have gathered. So with this, again, I congratulate my good friend and colleague, Dr. Ranita Nagar Madam, and also our director, sir, Santa Kumar sir, who always is very supportive for all such kind of program. And Dr. Hitesh Thakkar is an emerging expert in law and economics, I'll tell. I call him like that. And he is attempting, and he's also seriousness in this kind of research. I really appreciate. And So the student member, TRA, everybody contributes, but major contribution is by the head and the member. So with this, I again congratulate you, and also I hope that this workshop will bring very fruitful conclusions and suggestions, and which will provoke all of us to do further research in law and economics. Thank you, sir. Thank you, madam, and thank you, Hitesh, sir. Thank you, all the participants. Thank you very much.
Thank you so much, ma'am. We're all very thankful for your presence today. Now, I would like to call upon Professor Dr. Ranita Nagar, the Director for GNLU Center of Law and Economics and the Professor of Economics at Gujarat National Law University.
Your mic, madam. You're muted.
Thank you, Khushi. Respected Director, Professor Santa Kumar Sir, Director Gujarat National Law University, respected Madam Professor Dr. Mamta Biswal, Dean Academic Affairs, my convener and center member, Dr. Hitesh Thakkar, Shubhi, our TRA center members, and of course, all our participants. So there is very little to actually add after what Director Gujarat National Law University, Professor Dr. Santa Kumar has said. Very broad, very important, very pertinent aspects of law and economics, and quoting from Justice Oliver Wendell Holmes and quoting from Judge Posner. So, they actually cover the entire spectrum of the importance of this interface. I must say a few things. One, it is the environment of Gujarat National Law University, one of the top national law schools. The vibrant discussions between the the area of law and the other subjects, the interface of that. Very brilliant students who always keep us engaged and want to learn the latest development in the area of law. So that has been the catalyst for the work that we are able to do in the GNLU Center for Law and Economics. The points that our Dean Academics, as always, has raised are of great research significance. Madam has pinpointed areas of socioeconomic consequence, immediate socioeconomic consequences. As far as the point Madam discussed on tort law, there are established economic principles. I'm sure our students also know this. It's about assessing the quantum of precaution. So what Madam is suggesting, ex ante, it's a signal. If this is the tort liability, then that is just like a price is a market signal, that is a signal for any action that might include a tort. So a signal which can minimize the ex ante cost of a tortious accident, and calculation of that based on, which is famously known as Judge Learned Hand's equation of marginal cost of the accident and the precautionary cost. So it is an assessment of the two, and you are liable if the precautionary cost you have taken is less than what is mandated by the rule. So what happens is typically for more developed world, this minimum level is way higher. So therefore, the tortious claims, granted are higher. So laws are actually also therefore a function of the socio-economic reality of a jurisdiction. And I always say this, that the market, today we are a neoliberal market, and in this market we are all right when we talk about the efficiency. But the point that Director Sir was telling us was about the ethics. So if you go by the neoclassical idea of a market for profit maximization, we will not be able to pinpoint on the ethical and social justice issue. So that's why there is a disconnect between the Chicago School of Law and Economics and its application in India. So even when we talk in the class, it's a little difficult because we are more tuned towards the social justice idea, whereas law and economics of the neoclassical flavor tells us about efficiency perspective and not so much about distribution. So therefore, I think the purpose of what we are doing here is to demarcate this distinction between the socio-economic realities of a developed and a developing world. And once this aspect of social justice can be incorporated within the larger neoclassical Chicago School of Law and Economics, we would be able to develop the Indian perspective of law and economics. For example, the tort aspect that ma'am was telling us, if it is cost of precaution versus the probability of the accident, in India, given our levels of poverty, we will never be really able to show that this is the cost of precaution I have undertaken, and therefore, my harm should be addressed to this particular level. That would not be possible in a developing economy. So this hands rule concept, how it's a pure neoclassical concept. It can be mathematically tested, but does it take all the parameters of the Indian socio-economic reality? So these are the aspects that we would want to develop in our research, the workshop, and that is the continuous. I think every research workshop, every FDP, I have stressed this, that it is the Indian jurisprudence of law and economics that we are looking at, because the market understanding of only efficiency would really not address the the questions of the Indian society and Indian economy. So with these few words, because we have already 2:10, sir, thank you once again, Director Santakumar sir. Thank you very much for your very encouraging words. Professor Dr. Mamta Biswal, as always, the research question, the research standard, the research orientation is something you have always held very high as Dean Academics. And my conversations with Madam has pushed me at times to, many times I don't have the answer, I have not had the answers, but it has pushed me to go back and see, understand what the question is and try to answer it as an economist, a legal question from an economics perspective. I have tried. For most of the times, I'm still inadequate, but then the effort is on. So, ma'am, thank you so much for that contradiction that you always give to, all our, I think, center members, including me, because we discuss a lot. That has shown me the discrepancy between the Chicago School and its Indian application. And that discrepancy is something that needs to be addressed through our workshops and research efforts. So thank you. I will ask Khushi to take over the, I think, conclusion. I'll just make a point that for certain reasons, Dr. Hitesh has not been able to be with us. There is some unfortunate development. So I'm sure he will join us at a later point of time. With those words, Khushi, I hand it over to you.
Thank you so much. I would like to thank all the panelists here today for their presence, for their words and their addresses. I'm sure all the attendees here are quite grateful to hear what all of you had to say. Now, for all the attendees, we would commence with day one of our workshop shortly with the first session held by Dr. Satya Prakash. Thank you.
Thank you so much, madam. Thank you for all of you.
Thank you, Director Sir. Thank you, Dean Academics, ma'am. Thank you for your constant support.
sir.
Thank you very much.
Thank you, sir. Thank you, ma'am. And thank you, Khushi.
Could we please talk to the Surya Prakash, sir? He's facing some problem in joining. Kushi, can you inform that we'll start within 1-2 minutes?
For all the attendees present here, due to some technical difficulties, we will be starting our session in a few minutes. Thank you for your patience.
Good afternoon. Am I audible?
Good afternoon, Professor. Yes, you are welcome and audible.
All right. Thank you so much. Somehow things are not very, technically correct, and it took some time. So apologies for that. But okay. So
Understand.
do I go ahead with my talk presentation?
Yes, Professor, please do.
Okay. So I want to share the slide. I hope I'll be able to share it, but it is showing blank over here. I'm not able to put the tab on. So alternatively, I could present and, or maybe later we could either send the slide, or if it is not required, it's fine, whatever.
Professor, you can please start. We'll make arrangements for the sharing in the meanwhile.
Okay. Thank you. All right. So good afternoon to everybody. I'm very thankful to the Center for Law and Economics at GNLU and Professor Nagar and Thakkar, who kind of kindly invited me to this event, and so I'm really overwhelmed by that. And let's hope we have a good session. Fine. So in this session, basically, I wanted to talk about false litigation, which is taken up strategically by firms for tax evasion purposes. Why? I mean, this is some thing which caught my interest a couple of years ago, 2, 3 years ago, when we noticed in Calcutta that a lot of firms, they employ their lawyers to refute the tax claims by the government, and they go for legal litigation. They may win or lose the case. Even whether they win or lose, it of course had some bearing on the ultimate outcome, but their strategy was very simple, that they would refute the tax claim, and in the meantime, that amount they would lend in the informal sector. So how did it benefit them? It benefits them because the informal sector has higher rate of return compared to the formal sector. So that was their basic strategy. Okay. So there was a small study conducted by CSSS Calcutta, Center for Studies in Social Sciences, in which they got the statistical evidence, though it was, the sample size was pretty small, maybe about 50 firms or something like that, or some 40 firms. Not too sure about that, but it was pretty small a sample size, in which they did get evidence that firms were doing this. Now, what I'm trying to do in this work in progress, which I'm presenting or which I'm talking about, I'm trying to model that mathematically and see if the model kind of works out well. So this is what I wanted to talk about in this
Excuse
presentation.
me, Professor, could you try sharing? I'm sorry to intervene.
No, it's perfectly fine. So let me just go back and see. Okay, yeah, I guess now I should be able to share. So is my screen visible?
Yes, absolutely.
Okay. All right. So let me just. Okay, fine. So the basic idea was basically this, that the firms were engaging in sham litigation. The basic purpose was to delay the tax payments and to buy some time, because in the meantime, they can lend it to the informal sector, earn the rate of interest, which is higher. And in case the case goes against them, if the verdict is against them, then in the meantime, they can, pay back the taxes to the government. But in the meantime, they have anyway made huge profits. So that basically is the idea. And what I'm proposing over here is also a mechanism as to how that could be contained from the government's perspective. So two perspectives over here. One is the firms maximizing perspective, and other one is the policy perspective of the government. So that is the basic idea in this paper that I'm kind of presenting over here. Yeah, and this is what the title says, strategic false litigation and tax evasion by firms. Okay. All right. See, the basic motivation comes from, you know, typically in less developed countries, firms, I mean, there's a huge informal sector, and firms, a lot of the times they engage in informal sale of output, or either they will under invoice their revenues and pay less taxes. Okay. And obviously, if that is the situation, then it is going to lead to revenue loss for the government in terms of tax revenue loss. All right. Now, what I'm doing in this paper is that even if these guys don't sell in the informal sector, even if they don't under invoice their sales and all of those things, they can still earn their profits just by making use of sham litigation and just buying that time. So this is the basic stuff over here. Why this is possible? This is possible because there's a huge informal sector, which is anyway credit starved, you can say. They hardly get any credit from the formal sector. But there are small entrepreneurs over there who do need credit to operate. Okay. So one reason is huge informal sector. The second one over here is that the judiciary process is slow and or uncertain, and almost always it's both. So which gives them time. And if somebody were to look at the empirically the lifespan of an active case, or the time it takes to settle, I think it is pretty huge. So that is beneficial over here for the firms. And also, there is no active policy mechanism by the government to take care of the situation. It is really hard for them to identify if the firms are doing that. All right. Now, I'll just briefly kind of go through the literature. Sham litigation mainly kind of takes care of cases which are in relation to antitrust or patent related cases. There was an analysis by Clean in 1989 who highlights that. Okay. So this situation that I'm talking about, that has not been taken care of by sham litigation or the literature with regard to sham litigation. With respect to developing countries, again, the less developed countries, they do have a lot of research over here with regard to tax evasion, but somehow on this aspect they are silent. That this could be a possible mechanism which can, which could be employed by the firms for the purposes of tax evasion, or at least deferment. So I'm basically talking about over here both evasion and deferment. Okay, so if the firm is caught, or basically if the verdict goes against the firm, then at least the firm has kind of deferred the tax payments. And if the verdict is in favor of the firm, then the firm has totally evaded the tax payments. Okay. All right. So the literature that you see over here on the slide, they do not necessarily talk about what we are trying to capture over here. Now, just a very brief snapshot of what the research, the project found, Marjit and Mitra in 2015. What they noticed was, this is pertaining to Calcutta, West Bengal. They noticed two things. One was that about 30 to 40% of the firms, they opted to go for disputes. And among those firms, about 70 to 80%, they were the consistent gainers. How do we get this information? We got this information from the tax lawyers of those firms who were fighting those cases for those firms. Okay. And so this was one finding in that study or the project. The second thing that they kind of got was as the sales revenue of the firm increased, or if you have a bigger firm, more often they would kind of dispute the tax claims. So the number of tax claims or the disputes, they would increase in revenue. Okay, so this is the basic background of what we're going to kind of see in the next few minutes. So if I just want to take a minute and sum up the story that I'm trying to narrate over here, is I'm just trying to kind of create some kind of a model which is justifying this behavior of the firms, justifying as in from the profit maximization perspective. And after that, I'm proposing a mechanism which the government can use And that mechanism is kind of containing this activity. Okay. All right. So this is just a simple graph where we plot the number of disputes as against turnover, and you can see this that it typically is rising. You see that the black curve is falling and then going back again. This is perhaps the small sample size issue. The sample size, as I said, is not very big. Okay, so that's how the graph kind of comes down and then goes up again. All right, fine. Now, going ahead, this is the model that I'm creating. So we consider a firm which has earned an income of X and is liable to pay TX, T being the rate of tax. And we assume that the taxes are progressive, which means they are increasing in your income. Okay. So that's the basic stuff. But somehow the firm is contemplating, false litigation to appeal against the tax claim. Now, the thing is, it's a two-stage game kind of a stuff. If you were to simplify it, the suit is filed now and the verdict comes tomorrow, which means the suit is filed in stage one and the verdict comes in the next stage. Okay. The firm claims that it has earned X tilde, lesser than whatever whatever its actual amount is. We are calling X over here. So basically, it is underreporting of income, and that unreported income goes to the informal sector. That is the basic idea. There is a probability, which I'm calling a rho, with which the verdict can go against the firm. As we know, since the verdicts are pretty uncertain, you can never be sure who's going to win or lose. So that probability, I'm calling that to be rho. Okay. Even if the government's claim is correct that as a firm you earned this much, still it doesn't make much difference to the firm because of the judicial process. The firm can still get its profit. So as we said, there are two things over here, which is one is deferment and the other one is ultimate tax evasion. Obviously, the ultimate stuff is best for the firm, but deferment is the second best. Okay, so any of these is fine. So therefore, with the probability rho, the firm is paying this. I think I would want to annotate it at times. Let's see. Yeah. Okay. So with the probability rho, this is what the firm is paying. It will have to pay this. Plus, it doesn't really pay this. It also pays the rate of interest in the formal sector, which is small r, and it is also paying a fine, which is positive. Okay. One thing which we should notice over here, that the firm is paying taxes to the government on the squared amount of the underreported income. So if the actual earning is X, the firm reports as it is X tilde. So the ultimate tax it will have to pay if it loses the case is on the amount X minus X tilde square of that. Okay, so say for example, if the underreporting is 40 bucks, the firm has to pay a tax on 40 square. All right, so that is the thing. And we also assume that there is a litigation cost, which I'm calling this to be L over here. And for simplicity reasons, I assume it to be constant. It doesn't necessarily have to be constant, but that would not change my results. Okay. All right. And this is the benchmark model that I have set. And there is no informal sector as of now. As of now, there's no informal sector. What we will notice over here is this is basically that V function that you see on top, that basically is the objective function of the firm. Okay, so this X is what the firm earns. This is how much taxes it pays. It under reports, it says I have earned X tilde, so it pays tax over here. And then after it pays the taxes, whatever is left over, it invests that in the formal sector. So therefore this expression. Okay. And if it loses the case, then it has to pay this thing, taxes. So therefore negative sign in this row, and there's the square of the evaded amount. And then it is paying this rate of interest, fine, and there's a litigation cost. Okay. And just to remind ourselves over here, we are saying T is a function of X, which is progressive taxation. All right. Now, if we do the standard optimizing behavior of the firm, what we notice over here is that this is what comes about. And the object, if you put this thing back into the objective function of the firm, there's something that comes about over here. This becomes important because if we will just go to the next slide and see. So this is a situation where the firm is evading. So we want to compare in the next slide. Is it making any sense for the firm to evade? Which means we will compare two situations. If it does not evade and if it does evade. So the firm would evade if it is profitable for it to evade. That is the idea. All right. So if it does not evade, very simple. So the firm is earning X, okay, and it has to pay taxes on that X. It has to pay taxes on this X. So this is what and after payment of the taxes, it can put that amount in the formal sector. This is what its profits will be. Okay. On the previous slide, we saw that this thing, the value function is when it was evading. This pi of X you see over here is this thing, the entire stuff, this thing. So if I were to subtract this from that, I get this from this expression over here. Okay. And what you notice over here is this part is positive. It increases. So as your income goes up, this part goes up. And since we have said that the litigation cost is flat, therefore in the graph you see a flat line over here. And this part over here, this is shown by this upward rising curve. So a firm which is earning a revenue from 0 to this much, it will not make any sense for that firm to refute the tax claims for the government and enter legal litigation. Why not? Because this is the cost. See this? Flat line is the cost and this is the benefits. So obviously it doesn't make any sense. But the moment the firm attains X hat, it gets ready for legal litigation. And if its revenue is anywhere beyond that, obviously it will do that. So what we'll notice over here is that it is paying off for the firm to refute the tax claims and enter legal litigation. Okay. Before I just go ahead, I just wanted to ask Dr. Nagar, I have how much time? I think till about 2:50 or 3 or something, right? Hello, am I
You can
audible?
take, sir, you can take till 3-5. There is no problem.
Okay, fine. I will try to keep my stuff as to the point and crisp. I just wanted to have an idea. All right.
Yeah.
All right. Thank you. Thank you. So what we notice over here is this far. Once we do the classic optimizing exercise, we notice that it makes sense for the firm to evade or basically litigate against the tax claims. Okay, which is basically a function of the earnings of the firm. Okay. All right. So now let us go ahead. And this basically what we just saw is an absence of the informal sector, which means the earning differential is not yet over here. So when there is no differential, then it is making sense for the firm to, refute the tax claims. So now we will see as to what happens when there is a differential, when there is an opportunity of the firm to earn higher. All right. So now we are talking about on the slide, we say that we analyzing the informal sector as well. So we consider a case when the informal rate of return is capital R, which is greater than small r. So small r is the formal sector return. Say banks or something, if you put your money into bank, you will get R, small r. And if you give your money to the informal sector, you will get a bigger R. Okay, so big R is greater than the small r. All right. And the story is simple over here. The total evaded amount goes to the informal sector. So this X minus X tilde that we notice over here, that goes to the informal sector. Okay. And the rest, after you pay the taxes to the government, then you can invest that stuff into the formal sector to earn R. All right. Okay, fine. Now, we know that for this to be viable, this is something which is required, that the informal firms must not be able to borrow from the formal sector credit market. And that is largely true because they don't have a lot of collateral, for their loans and all those things. So therefore, they do not get the loans that they require. So the only resort is for them to kind of get informal loans. So this is the basic story that I'm trying to fit over here. All right. Now, once we inculcate the informal sector, then the objective function of the firm, it becomes like this over here. The equation that you see at the end of the slide. Okay. So the evaded amount goes to the informal sector. Therefore, you see this 1 plus R. And the reported income after paying taxes can be invested in the formal sector. And then you see this 1 plus a small r. Let me see if annotation. Yeah. So this goes to the informal sector. I mean, this part. This part. Obviously, this is the earning. This is the earning. This part, after payment of the taxes, is in the formal sector. It can be invested, and then this is what you will earn. And if you lose the case, the same story. So you pay a penalty with the probability of rho. I mean, penalty as in you need to pay the taxes first on the evaded amount, square of that, plus the formal sector rate of return and this fine. And obviously, there's the litigation cost. Okay. So the same benchmarks that we have seen, but we have now added the informal sector over here. All right. Fine. So what we notice over here is that this 1 plus R that you see over here, that is adding, more incentive for the firm to evade. Notice we said that even if the informal sector were not there, it makes sense for the firms to evade or underreport. So now if you have an opportunity to earn higher returns, obviously the firm would do that. All right. And then what we see over here is basically two things. This is the same exercise. Let me just again annotate. There's the same exercise over here when we are saying that evasion is going to make sense. Okay. Now, this is the added incentive, the interest rate differential. Everything else is what it was in the previous situation. Okay. Same stuff. Now, what we have over here, all right, let me keep it somewhere. Yes. Okay. So assume that small r and big R, if both of them were same, what would this mean? That would mean that a firm would not litigate until its revenues reached this level. Okay. But when you do have the other sector where the firm can earn higher, I'm talking about this situation, then the firm will litigate at a lesser turnover over here. See this? So when you have an opportunity, when the informal sector comes in, the smaller firms also enter, sham litigation. They also refute the tax claims and they also kind of litigate against the government for the opportunity of earning higher income. So this is that situation over here. So basically, now you require this much lesser revenue or earnings to enter into litigation. All right. Fine. Now, there are a few theoretical points which we just wanted to kind of, which we get from this work. I think some message came. I was thinking that let me just finish this and then I can either see the message or somebody can ask the question. Okay, and I was just, so kindly keep your questions ready. I think I will just take about 7-8 more minutes to kind of complete the entire story, and then we can have the question answer session. Okay, if that is fine. All right. Fine. So a few theoretical points which kind of are we getting from over here is this is very well established in the evasion literature that when the penalty is on total tax evaded rather than on the total income misreported, tax rate does not affect the optimal evasion. Why does it not do so? Because in the exercise of optimizing, the tax rate cancels out in the first order conditions. So that won't happen. Okay. Second, we show that as tax rate increases, the extent of false claims that kind of becomes lesser. So there's better reporting by the firms. Okay. Third, in the usual cases, they have not discussed this opportunity that 1 plus big R, that can be one of the attractions for tax evasion. It has not been dealt with. Recently, there was a paper by some 2-3 of us, European Journal of Political Economy, where they do have done some kind of similar work, but then the probability of verdict going against the firm and all that, that is endogenous probability. Here, I'm taking an exogenous probability. The fine stuff as to he has to pay taxes on how much, they have taken a linear thing, and I have taken a square stuff over here just to see some if there are some drastically changed outcomes coming about. So this is still work in progress, but we're just trying something. Let's see how it works about. So yeah, in the literature this far, that 1 plus capital R hasn't been kind of analyzed. Okay. And see, one of the most important thing over here is we also get a computable relationship for determining theoretically the informal rate of return. See, we know that the informal rate of return is way higher in comparison to the formal rate of return. It can also be somewhere about 200, 300% and things of that sort. Okay. So we have a formula, we have derived something from the equilibrium condition that informal, rate of return will be something like this. The last thing on the slide. All right. Typically, sham litigation leads to a lot of problems if you think about from public policy perspective. Okay. The first thing is loss of tax revenue. Why is that a problem? That is a problem because it will hamper provision of public goods. This is one of the sources of revenue for the government, or rather the most important source of the revenue for the government. Okay. The other one is typically in developing countries, or generally, if you think about it, informal sector is not something which is looked up to. It is kind of thought to be undesirable, even though it contributes heavily to the GDP and the employment. Roughly about 50% for the GDP and about 90% for the employment. Okay. So if you think about from that perspective, then you can say that the formal sector firms are gaining, obviously the higher rate of return that they are kind of having, they are gaining at the cost of perpetuating the informal sector from policy perspective, which is kind of undesirable. But obviously, again, we know that the government is also constrained by the resources and it cannot do much. And things which the government cannot do, this sector is providing. So it's a very complicated kind of a conundrum. Okay. Overall, it leads to enhancement of the informal activity. I'm talking about this situation, this paper that I'm presenting to you. The other problem is it is kind of creating more and more pressure or burden for the judiciary, which is anyway a lot pressured. All right. The number of cases, if you look at, and the number of courts and judges, I mean, it's kind of an overwhelming number. Okay. So it is adding on to that, and it is also kind of delaying the adjudicating process. The last one, I think, is diversion of resources to litigation. I mean, it is not very valid here because this is sham litigation. If it were proper litigation, one could argue from the perspective of justice and all that that is required, but this is sham litigation. Okay, so therefore problematic. Diversion of resources to sham litigation, which could otherwise be used to more and more productive purposes. So these were some of the problems that it poses. Now, a counter mechanism that I was talking about, what we are saying over here, I'll kind of not go through the slide. I'll just give the main point. You can see the slide. The basic idea over here is this. We are advising that if the government were to, take some money up front, it says that fine, you can refute the claim, but give me a part of that upfront, and you go for the legal thing. You file a suit. Let's file a case, and if you win, no problem. I'll pay you with the fine and all of those things. And if I win, you pay me with the fine and the agreement that we had. So it's a symmetric kind of an agreement. Whoever loses has to pay the other party. Okay. But what we're saying over here is the government is asking the firm to give something lump sum before the case starts. It says, you give me this much and then go for the case. This is what we are advocating. The moment we inculcate that stuff, then, and the same exercise of optimization, and then what we basically see is that the firm's strategy of sham litigation kind of weakens. Okay, and if you want me to just go through these terms over here. Yeah. Okay. So this beta basically is the fraction that the government is asking for. Beta of what fraction? The tax amount. Okay, it says ki jo bhi tum, whatever dispute you are doing, so if the disputed amount is 100, the government says give me a portion of that. So this is that stuff. And then everything remains the same. So the firm actually earns X, reports X tilde, pays a part payment of the evaded tax amount. So this basically becomes the evaded tax amount. It pays a part of that to the government. Okay. And then the rest, whatever is left over, this it puts to the informal sector. So it earns capital R. And on the reported income, it pays taxes, 1 minus T, and then whatever is left over, it gives it to the formal sector. It can put it in the bank or something and earn small r. This again is the same row probability that the firm loses. Okay, if it loses, then it has to pay 1 minus beta, and this is the stuff, square of the term. Notice, don't forget this. Why 1 minus beta? Because it has already paid beta to the government over here. Look at this term. It has already paid that. If it loses, it has to pay the rest remaining, and also the fine thing over here. Okay, but the firm doesn't always have to lose. It's probabilistic. So this is what happens if it loses. So if it loses with the probability of rho, it will win with the probability of 1 minus a. This is when it is winning. Notice the signs carefully. This is negative because it has to pay to the government. Okay. All right. And if it wins, then it will get back what it paid to the government with the square term stuff. And the government now has to pay this. And this L is the litigation cost. All right. So we do the same exercise, and then we arrive at certain terms as to what should be the evaded amount and things of that sort. All right. The basic point over here is, I will go to the next slide. This exercise is exactly the same as what it was before in the other two cases. So again, we see that it still makes sense for the firm to kind of evade, even though the incentive declines. So yeah, this expression over here, this is always the benchmark case. The firm does not litigate, refute the claims. And this one is the value of the objective function of the firm if it is practicing sham litigation. So from this value, if I take away, if it were not to litigate, I get this expression, which basically is positive. Well, this relationship will hold. This relationship will hold like what it was before. Okay. Now, coming to the graph over here, when beta is 0, beta 0 meaning the government is not collecting anything upfront. Then look at the revenue or the sales required for the firm to litigate. It is X0. Okay. And when beta is positive, meaning when the government is employing this mechanism that give me some fraction. So beta positive meaning, it is taking that stuff. Beta 0 meaning the government is not taking anything. So when beta is positive, then the income has to be at least this much for the firm to litigate. I hope we can see this, which means the reporting is increasing by this magnitude. The reporting by the firm is increasing by this magnitude. All right. So basically what figure 3 shows is that fewer firms will litigate, and especially the ones with smaller turnover, they will not litigate. Okay. And this policy of upfront payment it basically improves the reporting of income, as we said. The reporting of income is improved by this magnitude. So is it beneficial? Yes, it is. How? Because it adds to the government revenue in the current time frame. The government may do anything it wants to. It could just put it in the bank and earn the small R. Obviously, the government is legally prohibited from putting money into the informal sector. Okay. And or it could earn a shadow rate of return in the future, which is greater than small r. Okay? So in essence, finally, to conclude, from the government perspective, the beta has two positive impacts. One is it curtails sham litigation by firms, and the other one is it enhances the revenue of the government. Okay, so this is what I have, and kind of done with this. Sorry, we ran a bit late, but we will come back for any questions if we have. So I think I will stop sharing now. I'll let this be kind of on. Please ask questions if you have any. I hope I'm audible.
Yes, Professor, you're audible.
All right. All right.
We'll wait for some questions. Shubhi,
Yeah,
if there are
sure.
any questions, you could please.
Yes,
Shubhi?
ma'am. I don't have any questions on question and answer tab. So if anyone has any question, they can put it up there. And
I think somebody had written some question, which in between, Rumba, I said we can do it slightly later. So maybe that person can ask, or anybody. Yeah.
Sir, I haven't received any question and answer, but if there are any questions, the floor is open.
Okay, I think there was somebody who asked a question and saying that why do we have to square the unreported amount while calculating the tax that the firm has to pay after losing the litigation claim? This is just basically one of the mechanisms to kind of say that penalty is severe. You don't have to necessarily square, but by squaring, we're just making the penalty slightly severe. So if you did not pay tax on you say 10 rupees, then now we are saying that you will have to pay tax on 100 rupees just to make the penalty severe. All right. Any more questions?
Thank you, Professor. Great work. I was wanting to know that with this digitalized payment and all that, do you think that would have reduced the sham litigation because of better reporting?
Yes, it will definitely have some impact over there. Okay. Because since digitization takes care of things, very clearly, so it will be more difficult, of course. It will definitely be more difficult for the firms to litigate that much. So it will definitely have some negative impact on that. That now they might not be able to kind of, say that I haven't earned this much or something because everything is recorded. So I think that would be the impact.
Thank you.
So we have a question from Ms. Jyoti Jindal. She is asking, how do you think can informal sector activities be taken to the formal sector?
Okay. See, I think one of the biggest things which can be done over here is inclusivity financially of the informal sector and some kind of, you need to boost that sector so that people can come up to be a part of the formal sector. Again, it's not just one stuff, it's a very kind of a complex kind of a situation. Okay, because they also lack property, they don't have a lot of collateral, so loans they will not get, which means you have to provide loans. Secondly, they may not have the ability, so you might need to train them and things of that sort. And one thing that we need to kind of see over here is that informal sector is very huge. In India, in the Indian context, this is roughly about 80%. okay, or slightly over 80%, 81% or something like that. So obviously, the government can make an effort, but then it will take a lot of time to get all the informal sector into the formal sector. Okay, so but there'll be a host of things which are required to be done. But I think one of the most important things is financial inclusivity. And in countries where informal sector is huge, financial inclusivity is lesser and lesser because of various issues, namely the infrastructure required and the size of the informal sector. Okay. Yeah, I think some people are writing questions, but let me see.
So there is a
Uh,
question from Mr. Jacob George. He has asked, how do you factor in government changing policy, like in the recent decision to reverse retrospective tax?
how do you factor in government's decision to changing policies?
Yes, sir.
Uh,
Professor is specifically asking about the retrospective tax.
okay, okay. See, I'm not very sure as of now that in this context how that will be kind of effective. I mean, how things will change in my model over here. Uh, so I'm not very sure because necessarily the mechanism in which the taxes are evaded and the place where it goes, I think they definitely should have some kind of intermingling. I am also working on something when the government is realizing that if the evaded amount goes to the informal sector, the government sometimes allows that. Obviously not legally, but it will be lax on that policy front. So in this situation, if the government were to take care of that, it will say, fine, do not give the taxes retrospectively, or it will be slightly kind of lesser strict on that. But I'm not very sure as of now as to how that will have an impact in my analysis over here. Maybe I will kind of try to work with that.
So there's one more question for you. That is, how can
Yeah,
the government help in increasing the formal rate of return?
formal rate of return. Okay, okay. See, actually, it goes like this that money or returns, they are economic goods. Okay, and the classical assumption that more is preferred to less will does necessarily hold over here. Okay, which means the diminishing marginal utility for money, as we know, is very it falls very slowly. So the point over here is, in comparison to the informal sector return, the formal sector return seems to be lesser. But if you compare to the formal sector returns of other places, then this one may be slightly higher. Okay, so the question as to how can it make higher? The real issue is how high. Okay, so and the government can do so based on the other economic indicators and economic health of the country. But then this thing as to how can it make higher? The real question is how high do we want it? All right. So that'll be, I think, slightly iffy. But then, yes, of course, if it does want to increase it, however high, then it has to take certain kind of steps to do so. But then I think from the policy perspective, what is crucial is how much do you want? Okay. I mean, this thing is going now. Assume one simple response somebody could give is, what if the formal rate of return is more than the informal rate of return? Obviously, then nobody would want to give the money to the informal sector. So it is not absolute, but in the relative sense that our formal sector returns in relation to what? So if there is country A, and if its formal sector returns are more than what we have, then the capital will flow to that country. So that's why I said I think they have to have a clarity as to how high do we want that. All right. Any more questions we have?
So we have three more questions.
Yeah,
Um,
please.
so Mr. Shibanshi Tyagi is asking, firms are
Huh,
taking risk by lending to the informal sector. Is the
huh.
risk included in this analysis? That is the effect risk on rate of return.
Yes, it is implicitly included. So I think basically what she's meaning is that what if the borrower's default? I guess that is what she's hinting at. A risk of bet is basically that, right? That when you're lending to the informal sector, what if people default? Okay. I mean, just correct me if I'm on the right path. Is that what she's saying? Because the response will depend upon what she has in mind.
Yes, sir, that is what she meant.
All right. So let us assume that that's what she's saying. Now, we have empirical evidence that in the informal sector, there are two things happening over here. The borrowers anyway cannot get anything from the formal sector. So these people are the last resort for the borrowers. Which what I'm hinting at is default rates are pretty low in the informal sector. Why? Number one, these guys are the last resort for the informal borrowers. Number two, this market is highly organized. We know that nothing is written, no contract on all of those things that we know, but then it's very highly organized. Okay, so if somebody defaults once, maybe next time he or she will not get loans. Okay, that can be one stuff. Other stuff is that recovery is done through a lot of extra legal mechanisms in this sector. And sometimes it can be much more than what you have borrowed, up to and including your life. So defaults over here are pretty less. Therefore, the firms which are lending to this sector do not necessarily have to bother about the defaults or the risks. Okay. I think two more questions, right? In the meantime, I think somebody has written to me, Sandeep C, that this mechanism that I am proposing that may discourage genuine litigation. Right now, that would not happen. Genuine litigation in the sense that if you're reporting correctly, or if the government is wrong, then there are higher chances that you will win. I'll not say 100%, but then there are higher chances that you will win. So that will not kind of discourage a genuine, litigation over here. So that should not be an issue. Okay.
Yes, sir. Now, one question that I have received is from Mr. Ronak Jain. He writes, can you please once again shed light on the upfront payment policy that can help in better compliance and reduce sham litigation? Why don't we take into account the uncertainties of the informal sector while calculating whether it's profitable for the firm to go for sham litigations, as there may be bad debts for the firm?
Okay. So see, we are not over here thinking about the history of the firm as to what all other stuff it is into. Okay, what kind of relationship it has had with the other competitors and the things of the chart. All that we are saying over here is very simply two-stage game. That a firm is earning something. It is kind of, it wants to say it doesn't want to pay taxes very straightforwardly, and or at least delay the taxes. Whatever that amount is, it will give it back to the, I mean, not back, it will invest in the informal sector and earn higher rate of return. That is the basic story from the firm's perspective. Government is losing tax revenue, obviously. So if the government wants to contain that, it is saying, fine, whatever the disputed amount is, you give me a fraction of that and then go for the dispute. If you win, I will give that thing back to you with the fine. And if I win, you give that stuff back to me. Now, over here, we are ignoring every other historical aspect of the firms, which is not very important over here. Okay. Like if it has debts and all that, in that case, then you need to make a model for that one single firm. But I'm talking generally over here about anything, any firm which is earning and saving the tax amount and then putting it where all. That's the story over here. Okay. I think people can ask questions. I mean, instead of writing, directly पूछ भी सकते हैं. I mean, of course, provided you have time, because I think if we have gone over that, but I'm fine with it. I have no issues.
So we have covered all the questions because the last question that I received was from Sandeep C, and you covered it that.
Okay. All right.
Okay, thank you, sir.
Shubhi, has Ronak's question been asked? Because I can see Ronak.
Yes, ma'am. I've asked his question. The question that sir just answered was from Ronak Jain.
Okay, fine.
I hope the answers are okay, or people can get back to me. It's okay if they are not satisfied.
We'll put, if it's okay with you, we'll put up the email ID with the participants, and they can be
Yeah,
further
sure,
communicated.
sure.
Thank you.
Thank you so
All right.
much, sir. Kushi,
Thank
over
you
to
so
you
much.
now.
So I can stop sharing now, right?
Yes,
All right.
Kushi.
Thank you so much for such a productive session, sir.
Thank you, Khushi. Thank you so much. Thank you for calling me.
Thank you, Professor. It's our absolute pleasure. I'm Professor Nagar speaking. Thank you very much. We look forward to your sessions in future.
Thank you so much, Professor Nagar, for having me for this talk. And yeah, let's hope we have a long and a fruitful association. Thank you so much. So I think the meeting is over, right?
Professor, your session is unfortunately concluded.
No, it's okay. It's okay. So I can go, is it?
Yes, Professor. Thank you so much for your presence.
All right. Thank you so much, Professor Nagar. Thanks a lot.
Thank you. Thank you.
Yeah. Bye.
So that was the end for the first session of day one. For our second session, I would like to welcome Professor Dr. Anita Nagar. She has been with Gujarat National Law University for quite a while now and is the head of the GNLU Center for Law and Economics, as well as the professor of economics here. She has an array of publications and expertise on the subject of law and economics, not just in the terms of papers, conferences, or presentations, but she has been instrumental in the course of law and economics to develop in India. To say that she's an expert in law and economics is truly an understatement, and this comes from a personal experience. We're all very pleased to welcome her today for our second session, which she will be taking on the topic of neoclassical economics of the Constitution.
Thank you, Kushi. That was the introduction was, I think, typically coming from a very dear student of mine. So, so all the nice adjectives, but yeah, all of us have been trying. India has a lot of experts in law and economics. We are happy to do what we could in GNLU and national law schools. So what I'm trying to talk about is the Constitution's functional division of power through the lens of constitutional amendments. This is a project that it's an ongoing work. It's done through my center and of course the students. We've had, important inputs from experts in the area, and it's an ongoing work. So all I have is a bit of a theory maybe that I'll be trying to discuss, and some very initial observations. Like I said, initial observations. So what are we trying to do? What are we trying to look at? We're trying to, in terms of numbers, look at the constitutional amendments and see, without going into, of course, all the micro details of the amendments, but just in terms of numbers, what is the first impressions that we get while looking at a central question of two microeconomic aspects. The microeconomic aspects are competition and lowering the degree of competition. So these are the two central neoclassical rational choice model, which tells us about some patterns of allocation of resources. Also through, so that allocation of resources would take us to productive and distributive aspects of the market economy. And it is said that under the neoclassical framework of rational choice, that just like the market is a efficient allocative mechanism, applying the public choice theory to constitution, looking at the works of Buchanan and of Robert Cooter, and the work of course, Professor Ginsburg and Indian scholars, Shruti Rajagopal, and of course, learning from Professor Reggie, who works in constitution law. Those are, those would be the backdrop mention of important literature. So constitution as an allocative mechanism, what are we meaning by this? Very simple. We are actually talking about Adam Smith's, idea of division of labor. So when the productive activities increase, division of labor leads to specialization, higher efficiency, and it also restricts inefficient overlapping of the interaction between manpower. How do we apply this to the constitution as an allocative mechanism? Well, political processes, and a constitution would be the helm under which the political processes are defined. Political processes for the purpose of functional category, for the understanding of the functional role of this allocative mechanism of the constitution. So therefore, political processes are of interest to the economist, because just like the market allocates resources, so does the constitution through its political processes allocate resources. And in that process, the central feature, one of the central features, because when you talk of amendments, it ranges across a very, very wide area of study. But one of the central features of the constitution in most of the constitutions of the world, and including India, would be separation of powers. And separation of powers, it is through the separation of powers that resources are identified, allocated, reallocated, which broadly is the political process. And it is, this process, gets this catalytic, the forces, the catalytic forces that come into play would be diverse, depending on, of course, the demand and supply of the rules, the possibility of extension or contraction of that rule. And as we know, rules would create rights, and rights are resources. So we look at this public choice theory by understanding the role of the interest groups. It's when I say catalyst, I say these various diverse interest group action that create the demand for a new rule or an expansion in the rule, or a complete change in the rule, right? So exactly like the market would allocate resources through the demand and supply forces under an application of public choice to constitution, the interest group would affect the demand side of the allocative process, and the um, distinct separate organs of the government would determine the the supply side of the rule within a constitutional structure. And if the interest group activity is strong enough, then the constitutional structure is also amenable. What are the assumptions when we apply public choice? That individuals are governed by self-interest, typically like we do rational choice in market transactions. The assumption is that individuals are governed by self-interest in private choices, as also in making social or political choices. So there's a lot of literature on this. This extends to individual groups of citizens. So these are the interest groups, which are groups of citizens who interact with the branches of the government, that is the legislature, executive, and judiciary. Once again, just like the resources when we talk in a market transaction situation are scarce and need to be optimally used, similarly, resources available for political processes are scarce, and political rules would determine how the competing demands, because multitude of unmet demands, multitude of diverse interest groups. So the political processes determined by a given rule would allocate the resources, or also, how the resources would be allocated through the political process would be arbitrated. So these are the central assumptions of the public choice theory. Now, this is a lot of work that comes from Shruti Rajgopal's work, wherein she has spoken of, talked of, written about, the whole syndrome of rent seeking that comes along with interest groups. So interest groups and the rent seeking phenomena. How do we understand rent seeking? So rent seeking typically would be the expenditure of resources so that these monopoly rents can be acquired, which could take the form of a license for, to start, to get some mining permit, or to start a restaurant, multiple economic activities. So these would be, monopoly rights, and therefore they lead to monopoly rents. But in literature, it is said that rent seeking is perfectly legal, but it is not productive because, as we know, resources have alternate uses, and spending resources for donation to political parties or election campaigns are not the most productive deployment of the resources. So that is the rent-seeking inefficiency that comes with interest group action. So interest group action and the demand side, of the rule-making political process, seen along with the supply side dynamics of constitution rules, wherein typically when we talk about the separation of powers, we look at the legislature, the executive, and the judiciary. And as I have already said, that the functional division is, according to Adam Smith's discussion. Yeah, I'll take up the questions, Ronak, isn't it? So I was telling you that because resources have alternate uses. So, putting in a lot of resources for election campaign or for influencing could be put to more economically productive uses. So that is one, one problem, one inefficiency with rent seeking. Of course, when the gains from the rent seeking are higher than the resources deployed, then for the individual actor, the gains are higher. But when you look at an aggregate study, then what we know that what is efficient for an individual would tend to get inefficient at the aggregate level. So coming back to the supply side dynamics of the constitution rules, what we also need to see is that all these three forums that we have identified within a constitution, they all create rules, right? Of course, the procedure is distinct as far as each of these forums is concerned, yet they do supply rules. They make available a choice to the interest group, whichever forum the interest group would want to access. Also, that these three forums are complementary at times, and they can also be substituted at times. So, so depending on the cost benefit calculations of the interest groups and the cost benefit calculations with regard to the processes and procedures for the legislature, executive, and judiciary, there is an optimal combination that of costs with regard to both the demand and supply that can be met. Now, building on that background, wherein we said that the organs of the state and the interest group, so that's the interaction basically within the dynamics of the constitution, which prominently are demarcated by what we see as amendments. So the dynamics of amendments is being seen as an interplay of the as an interplay of the costs and benefits of the forums vis-a-vis the interest groups on one side, and the complementary and substitutability of the rulemaking on the supply side. From there, what we see is, as long as this distinction between the three organs are clearly demarcated, there's a clarity between the distinct functions, the organs of the government retain their competitiveness. So this is what I discussed in the beginning of the session, wherein I was trying to relate growing competitiveness given the distinct demarcation procedures, rules and outcomes of the executive, legislature, and judiciary with regard to the distinctness of their functioning, so that the competitiveness between separation of powers retains itself. That is one possibility, and we align that to the concept of a competitive market, because the competitive market has its efficiencies, right? So in that line of thought, distinct separation of powers has its competitive efficiency, unlike the situation of the demarcation getting eroded, which in terms of constitutional dynamics would be, let's say, transgressing into the domain, into the different distinct domains of the executive, legislature and judiciary. So if there is a transgression, it shows that the distinct demarcation is eroding, which therefore in terms of rational choice analysis would state that the extent of competitiveness is also eroding. So, which means that this interaction of the demand and supply of rules, given the distinct forums, in line with the interest groups, have consequences, have ultimate consequences. And those ultimate consequences are in understanding, higher degrees of separateness and therefore higher degrees of competition, or reduced degrees of separateness, that is transgressing into the jurisdictions, which would, functionally look like a loss in separateness, a loss in therefore competitiveness, and which in more familiar terms would be centralization. So we are looking at centralization vis-a-vis decentralization. The idea of separation of powers is inherent in the idea of decentralization, whereas entering into each other's domain would be signals of centralization. So this is the theoretical backdrop, and strong interest group activities, they, depending on the, like I said, the procedures of each forum is distinct and different. Therefore, the cost of each forum is distinct and different, both for the interest group and for the supply perspective of the rules. Which means that every time there's a reduction in the cost of approachability of these forums, an increase in the certainty of consequences of approaching a distinct forum, it is an incentive for interest groups. So amendments, will be looked at from the perspective of whether the costs of these forums per se. So an amendment impacts the procedure, the jurisdiction, both. And as a consequentialist, what does it do to the cost of the interest groups, and what does it do to the cost as far as the functioning of the three forums per se is concerned? And clearly, amendments bring about changes in the costs and consequences. So clearly, for an interest group from the demand perspective, would be incentivized, attracted to a particular forum more compared to the other, given decrease in the cost of approaching that forum, and given higher certainty of approaching the forum. And sufficiently strong interest group activities would create, limit, or expand the rule at individual forums or multiple forums. So once again, looking at amendments from an interest group activity. Therefore, keeping the benchmark of the degree of competition, the level of competition, and trying to test it from the perspective of whether this separateness, oblique competitiveness of the functioning of the three organs remain intact or become robust, or there is more of a transgression into the jurisdiction of each of the forum, and whatever the outcome is would tell us whether the movement through constitutions is more towards centralization of power, or it's moving towards diffusion of power, right? It makes sense also to therefore understand that the features, the central features of the basic structure of the Indian Constitution, with features of, separation of powers and federalism, if you look at it from the rational choice theory, they are instruments that ensure competition, and therefore the efficiencies of the competition with regard to diverse interest groups. And particularly so in India, given the diversification that we have, and therefore the multiple interest groups and all of that. So looking at the amendments from this perspective would give us some ideas on what is the trajectory with regard to the amendments. Are we moving towards a competitive constitution, or more monopoly constitution, or centralized constitution? And this is to be looked at not, based on any, is to be looked at based on the consequences, of the numbers that you can find within the amendments. Also, dispersed interest groups with distinct economic and political demands, retain the competitive element in the dynamics of rulemaking. So like I said, separation of powers and federalism, I mean, just to talk about two central features other than multiple other features in the Constitution. It makes sense that when you have strong regional parties, when you have very distinct economic agenda as far as election manifesto is concerned, these represent these dispersed interest groups. And therefore the combination of the forum, the constitutional rule in place, and the probable dynamics of changes in the constitution rule. But one thing is for sure, that as far as the first point, the first feature is ensured dispersed interest groups with distinct economic and political demands would retain the competitive element in the dynamics of rulemaking. Whereas dispersed interest groups, so yes, India still has dispersed interest, but with low voice. When we say low voice, we're talking about representation, which would, the outcomes of the elections tell us that over 70 years, we have enough data on that, would represent weak regional parties. And common economic agenda. This is important because distinct interest groups have to retain their distinction, right? Because if the interest group demand is distinct, and that distinction is not just at a theoretical level, but it finds voice and action within political processes. That's the only parameter that would ensure the competitiveness aspect of the Constitution. But what we see over the last 70 years, we do see dispersed interest groups. We have not seen interest groups disappearing. But what has changed is the representation, as with the parameter of the strength of the regional parties. And more interestingly, which has happened over the last let's say since 1980s, what has happened is the distinction, one important distinction disappearing between these diverse interest groups, and that is the economic agenda. When I said after 1980s, I'm sure we will be able to, see that the economic agenda has become common post 1980s. Pre 1980s was, pretty much high on socialist policies with interim space for, you know, uh, market-based outcomes through political processes. But post 1980, if we see from the point of competitiveness, which is represented through interest groups and through their typically regional parties, we see the economic agenda is becoming common. So that's a very, very important parameter to understand the distinction, erosion of the distinction. So if your economic agenda is homogeneous or more and more aligned to each other, then the interest group loses both its voice and its content, and therefore the dynamics of the interplay between the interest group and the forum, and finally the rule-making body, shifts, significantly shifts. And a fair way of looking into this shift is through the constitutional amendments. The amendments have brought changes in the position of the original bargain. I take you back to the original bargain, because after all, the Constitution is a contract, and there was an originality in that contract. The distinct originality was the strength of the interest groups, the distinct strengths in terms of their representation and in terms of their economic agenda, including political agenda, was very, very clear and very strong and very well represented and very well included as far as the original Constitution is concerned. So that's a good place to start the discussion from, because after all, it's a living document, but it has its origin. It is a certain promise to the people of the country at a given point of time. So, and because it's a living document, the trajectory of changes is through the constitutional amendments, and it is therefore interesting to know, how different, how far, how close, how efficient, how outcome oriented have these amendments been, because the Constitution itself came into place with the promise of fair division of Constitution surpluses. The Constitution came because there were ensured surpluses of coming together as a nation. And it was not just about these surpluses, but it was also, more importantly, about the fair division of the constitutional surpluses, or fair division of constitutionalism, right? So we want to look at the original and then take on the trajectory of the amendments and see. So the work that we are doing has multiple research questions. As of now, we are only looking at one particular research question, which is with regard to centralization versus diffusion with respect to the separation of powers. So I was telling you that the trajectory of the change, can sufficiently be studied through the constitutional amendments. because these are addition, deletion, and expansion of the rules, right? And like I've already told you, rules create rights and rights are resources. So coming back to the central question, to evaluate the consequences of successive amendments on the functional division of power and determine diffusion of power versus centralization of power, or from the rational choice perspective, competitiveness or erosion of competitiveness. So I'm still not really gone into centralization or monopoly. We'll see if the data, when sufficient outcomes are verifiable, we could demarcate the research question more strictly. But as of now, the initial findings can only limit us to the question of competitiveness or erosion of competitiveness. That's pretty much it. So up to 2020, this is just a bit of information for those who are interested. In the 70-year life of the Indian Constitution, 104 amendments have been added to the text at the rate of 1.46 amendments per year. Till 2020, 126 amendment bills were proposed, out of which 104 were passed as amendments, and the rest lapsed or were withdrawn. In comparison, the American Constitution has been amended 27 times at the rate of 0.12 amendments per year. And what is its life? The life of the American Constitution is 233 years. So 233 years versus 70 years with 1.46 amendments per year in the Indian context and 0.12 amendments per year in the American context. The Pakistani Constitution is, in 47 years of its life, so not the entire period, has been amended 26 times at the rate of 0.55 amendments per year. So this is restricted to 47 years. Beyond that, I have really not found the numbers. And the French Constitution has been amended 24 times at the rate of 0.36 amendments per year. So point is that the Indian Constitution has been amended, compared to major constitutions of the world, has been amended at a high rate, a significantly higher rate, 1.46. There's a lot of literature on whether this is good or is it not very good. Is this, flexible? Does it tell us about the fact that since India is young, dynamic, so therefore constitution amendments are taking those changes seriously into consideration, and therefore a very high rate of amendments? That is one literature. Another literature which would kind of contest the claim would be, maybe it's better to look into, it's better to look into this trajectory of what was original and what, and how we are bringing in the amendments, and see whether the original contract and the commitment of the original contract is upheld. That's one way of looking at it. There is literature which talks about the process of amendment and whether the process of amendment is high cost, low cost, and is that a factor which determines the number of amendments, or of course whether it is the interest group activity that determines the constitutional amendment process. So what we did at a very initial level is, we looked at 103 constitutional amendments on the basis of 11 categories. This was the methodology of what we have started on to, work with. Yeah, so what is the basis of these 11 categories? The basis of these 11 categories are the parts in which the Constitution of India is divided, the major parts, right? And so therefore the parts have been categorized as rights, duties, and DPSPs under the Constitution. One major category, land reforms, another category, lawmaking power of center and state, the third category, legislative procedure as the fourth category, power of executive as the fifth category, taxation, taxation as the sixth category. Seventh category is dedicated to emergency. Eighth category with regard to judicial power. 9 with regard to inter and intra-territorial relation. 10 reservation, and 11 language. These are the categories into which the Constitution of India is divided, and that is the same category that we have looked at. After looking at the broad categories, we kind of try to take a deeper dive into the amendments by focusing on certain. I've not written all of them because there were a number of variables we looked at. Some of the variables are the aim and objective of the amendment, whether the amendment was challenged before court, what was the public response over the amendment, the procedure and timeline of each amendment, a type of government when the amendment was introduced and when it was passed. Professor Ginsburg gave a very good suggestion. He said that, look at the number of words in each amendment. I mean, that is also, supposed to mean a lot of things. And like I said, we want to look at the amendment and then we want to look at the consequences of those amendments. So whether we can, find a correlation between the category of the amendment and economic parameters, economic consequences like national income, GDP, purchasing power, so, poverty, unemployment, employment generation in government sector, women participation in workplace, level and type of crime, sector-wise performance. Of course, we've not reached to this stage as yet. Like I said, very initial, observations. We have some very initial observations. This is how we, whether I don't think this would be visible. How do I put it on? Yeah. So this is how we try to, put the entire amendment process in numbers, with respect to the categories that we have formed. And this, like I said, these are the initial observations that we have. So if we categorize amendments into social, economic, political, others, we find these numbers as a percentage of the amendments that fall into these broad categories. So social, we see 27.5%, economic 10.8%, political 42.2%. So this gives us an idea that most of the action, interest group action, has taken place in the broad category of political interest groups and political consequences. looking a little deeper into the category, and subcategorize the broad categories into rights, duties, and DPSPs under the Constitution, land reforms, lawmaking power of the center and state, taxation, emergency, judicial power. So, again, the broad categories. What we find is, well, these are the numbers that we find. I think towards the end, I'll be able to tell you a little more about this. But what looks obvious is, like, when we look at the lawmaking power of the center and state, 8%, inter and intra-territorial relation, 13.8%, emergency, 5.8%, taxation. So these are amendments through which powers are added to the central government. And in this, if we look at reservation, we see 16.7%, and judicial power, 10.1%. So judicial power, so changes and amendments to the judicial power, it comes to be a smaller percentage of the larger amendment process that is going on. When we are talking about competitiveness of the separation of powers with regard to diversification or diversified interest groups with a voice and with a distinct economic agenda, if that be the case, as it should be the case, given the original, the original contract, the original contract in the form of the Constitution, if that be the case, then the question it raises is that the amendment, was it challenged before the Supreme Court? So that would tell us about the strength of the diversity in the interest group. So not the strength of the interest group, but the strength of the diversity in the interest group. And what we find is that to an extent of 77.5%, we see that it is not, the amendment is not challenged before the Supreme Court. It is in 19.6% of the amendments that it is challenged. So here, we do see that it raises a question on the strength, the distinction, and the voice of the interest groups. Why am I saying this? Because that's exactly what was reflected in the initial Constitution, the grand contract, with regard to the surpluses of that contract and the fair division of the surplus of that contract. Again, trying to check the diversity in the interest group, we ask the public opinion of the amendment, if any, right? And we find that in 11.8% of the cases, we see that there is no response. There is positive response, with regard to the public opinion about the amendment. It is 21.6%. Mixed response, so we've got cases of mixed response, and we've got cases of negative response. So public opinion is diversified. There is public opinion, but whether that opinion, so opinion is different from the fact of it being challenged, the amendment being challenged before the Supreme Court, right? So there is a diversification as far as opinion is concerned. If we look at the years in which maximum interest group activity has taken place, interestingly, we find it, and it makes perfect sense also. We see maximum activity happening in the period of 1987 and 1992. So this is what we were talking about, that post 1980s, we see pretty much a homogeneous economic agenda. And it is that particular economic agenda where there was, the so-called diverse groups did not have a voice, and therefore therefore we have amendments to the tune of, just within these 5 years, 18.6% of all the amendments happen in this phase of 5 years. Also 1969 to 74, the reasons are also very obvious at this point of time. 69 to 74 was before the emergency. It was, in that phase of nationalization. So you see the dynamics changing so much. This is clearly a different economic agenda. 1969 to 1974 is, distinctly different economic agenda compared to 87 and 1992. And then, of course, 1999 and 2004, we see again a lot of interest group activity, 13.7. But what is the difference between these periods? There's a lot of interest group activity, but we clearly see the strength of the interest group activity, isn't it? So the strength of the interest group activity, we brought in, 69 to 74. That phase, it is the phase of nationalization. So it's a different kind of interest group activity happening there. 87 to 92, there's a very different interest group activity that is happening, that takes suitable amendments to 18.6. And of course, it just gets stronger after that. So nationalization would tell us about socialist functioning of the constitution and its movement towards a more market-oriented neoliberal economy, state of constitutional amendments from 1999 to 2004. That is 13.7 there. And aligning that with the central question of what type of government was prevailing at the center when the bill was introduced. I mean, once again, 65.7% of this process was during governments led by a single majority party, and 34.3% is when we have a coalition government. So when we look at a single majority party, 65.7, we want to think about it in terms of the cost of approaching the forum, one, and cost of internal functioning of the forum. So if you have and the variable of certainty. So the more we have a majority party, the lower cost is of decision making. Coalition, but certainty of the outcome, but certainty of representation of the diversified group, that is not merited here. That's the consequence. That's not merited here. Coalition would default tell us that there are diverse interest groups, strong with a voice, with ways to impact the political outcome. So higher costs of getting the rule changed when you have a coalition government. So it's a cost and a outcome situation. Also, when we look at amendments relating to rights, duties, and DPSPs, and raise the question of the extent to which the fundamental rights of certain categories of people have been restricted. That's the question we raise. So there are multiple questions we've raised. It's only where we have some interesting findings that we are discussing. Interestingly, we see that 62.5% of the cases where these rights have been restricted, concern the civilians. And 12.5% of these restriction of fundamental rights concern the MP or the MLA. And 25%, is with regard to personnel of the intelligence agencies. I don't know how much time do I have. Shubhi, how much time do we have? Can you tell me?
Ma'am, the next session was supposed to start at 4, and
Okay.
Professor Panta has already joined.
All right. No, so I'll just conclude and kind of not really go into all these variables. And so initial findings once again, and once again just going by the numbers that we get by posing those questions. Looking at separation of powers once again, what is obvious from this slide is that the lawmaking power of the center and state, inter-territorial relations, emergency taxation, take up 32.8% of the amendments. I've already told you what was, in terms of being challenged before the Supreme Court, what was the outcome, public opinion, I have told you. Year of introduction, we've discussed, type of government, we've discussed, restriction on fundamental rights, we've discussed. This is separation of power in terms of the judiciary. So land reforms and scale of compensation. Interestingly, 33% of issues with regard to scale of compensation was placed beyond the scrutiny of the courts. Impact of the 9th schedule, we all know, another schedule which started with around 9 acts, and now it has reached 280 acts which are beyond the scrutiny of the judiciary. Taxation powers to the parliament would again go into the category of powers being added to central government. So initial observations show that in the ultimate analysis of 103 amendments, only based on the category of competitiveness versus erosion of competitiveness, we see alignment of more power as far as the the parliament is concerned vis-a-vis the judiciary, and this is please remember across the life of the Indian Constitution. So it is nothing about anything that has happened in any particular government. It is a trajectory of all those 70 years. So this is an initial observation. Further work has to be seen to find better correlations. Yeah, so with that, I will conclude. If there are any questions, or if we don't have, we're running late, so I don't know if questions can be mailed to me. I think, would that be better, Shubhi? Or are there questions?
Yes, ma'am. There are 2 questions. So should I mail it to you, or would you be comfortable answering right now?
No, I'm comfortable answering it. It's just that, we are running late. Please go ahead.
So first question that we have is, in the view of doctrine of separation of power, how do we acknowledge the 3 coordinate branches to be competitive?
Simple idea that like I also said that they compete with each other because there's a strict demarcation as far as the 3 functioning is concerned. There's a very clear demarcation, right? And therefore they work as checks and balances to each other rather than in concentration of the power. So there's a simple idea of competitiveness.
Thank you, ma'am. And the second question that we have is from Mr. Sandeep. He is asking, there is a public demand for Lokpal and independence of law enforcement agency.
Pardon, can you be a little louder, Shubhi, please?
Yes, ma'am. Am I audible now?
Yeah.
Okay, ma'am. So Mr. Sandeep is asking, there is a public demand for Lokpal and independence of law enforcement agency from political interference against corruption at the center and many other states, which is not met by supply forum like the legislature. What may be the reason for this? And secondly, he's asking, can the state create demand and be the supplier at the same time for social reforms which are not in demand within the public? What are the limitations of this?
Yeah, so as far as the latter part of the question is concerned, yes, the state can create the demand. Right? It is very, very easy for the state to create that demand. That is the latter part of the question. The former part is, so there is a demand. What was the first part, Shubhi?
Ma'am, the first part is there is a public demand for Lokpal and independence of law enforcement agency from
Yes.
political interference against corruption at the center.
Yes. So that's correct. What is being stated is correct. Yes, there is people, there's interest group, there is strong interest group that wants X through Lokpal. That's correct. So
And so what may be the reason for this? We also have a very interesting question coming up.
just a sec. The reason for this is interest groups, isn't it?
Yes, ma'am.
The reason is very simple. Interest group. That's where the demand comes from. So two things. So when there's a scarcity of the commodity, there is a demand. Number one. Second, demand can be generated also. These are the two parts, right? The demand can be the demand through interest groups can be generated. That is one. Second is when starkly there is a very necessary rule of law missing, right? Then there will be a demand for that, isn't it? Because it's so rule of law with regard to corruption is ancillary to all economic activities,
And ma'am, in this line, there's a very interesting question coming up from Ms. Shubhangi Roy. She's asking, considering lobbying is not legal in India, what are you using as proxy for interest group? Second, how did you measure public opinion?
Yeah, so for public opinion, when we go into the amendments, when you read the entire, all the details of the amendment, we get information on this public opinion. What was the public opinion? And what was the first part?
Considering lobbying is not legal in India, what are you using as proxy for interest group?
I am so for interest group, we are looking at the the demand that is created, right? The demand that is created for a particular rule or a particular expansion of the rule or the rule change, right? And even if it is not legal, it can be traced. It can be traced to the demand that has been created.
Okay, ma'am. I hope this answers your questions. And if there are no further questions, can we please proceed with the next session?
All right. So Shubhi, if you're telling me that I will conclude, I will. Thank you very much.
Thank you, ma'am. Khushi, over to you, please.
Thank you so much, ma'am, for such a productive session. Now, for the third session of day one, I would like to call upon Dr. Pant Murli Prasad for his session on environmentalism in India, the role of courts and pollution control board. Dr. Murli Prasad has been associated with the Department of Economic Sciences at IIT Kanpur and works in the interdisciplinary area of law and economics. His first book was in economic and legal approach to consumerism, first of its kind in India. He has developed and offered courses on law and economics and environmental economics at several higher education institutions in India and has been crucial in the formation of the Indian Association of Law and Economics. We are very grateful to have you today, sir.
Hello. Yeah, thank you very much for giving me an opportunity to share uh, my little bit of work on the topic environmentalism in India, specifically the role of courts and pollution control boards. Can I share the screen, please?
Yes,
Hello.
sir. Yes.
Just 1 minute. What is this? Yes. Okay, so is it visible to all of you?
Yes, sir,
Yes,
it's
sir.
visible.
Okay, so thank you very much once again. The today of the topic of the presentation is, as I mentioned, environmentalism in India, the role of courts and pollution control boards. The outline of the talk, it is basically the background and the theory, and the courts and the pollution control boards and overview and the conclusion. So when we talk about the background, if we look at the graph, which it is largely talking about plans plus what kind of we have targeted, we have achieved, and then what is the GDP growth, starting from water system to cyber system. So in the case of barter system, it is the people of the same community when they have the economic transactions. And when we talk about cyber system, it is people are of the global community. So given this huge transactions, what basically we want to look at this graph as a kind of environmental economist point of view. So when we look at it, basically what my simple connotation about this is that advancement of science and technologies will really, by looking at the forward backward linkages of agriculture, industry, and service sectors, they contributed US dollars around 2.7 trillion to the economy. And this really required to exploitation, exploration, and conservation of landlocked and ocean resources, for which the government of India is targeting for US dollar 5 trillion economy. So further, if we want to talk about the space technology and cyberspace technology, that really, which it is making market, non-market, and network transactions in the era of globalization. So all these things really leading in a sense that when we create wealth and accumulate wealth, as a spillover effect of that, we also generating waste and accumulation of waste. So this is one point which I would like to emphasize here. And second, if we look at few of the exploitation of natural resources in India, in a very simple sense, if we look at River Ganga, River Ganga is giving livelihood for around 500 million. Hence, there is a reciprocal in people to promote the health and wealth of the resources of the river, as well as the livelihood of the riverine people, respectively. So then, what basically it means? So it means over the at least in around 2000 to 2010 to 2018 for 8 years time period. We have really looked into the use value of river resources, particularly in the context of pilgrimage in Uttar Pradesh and Uttarakhand states, and then the ferry services in Varanasi and Kanpur. Largely, we put it in Varanasi, and then riverbed forming in Kanpur district. So all this use values of the river during the flow of water and lean flow of water really generated the resources for the people to the tune of 1100,000 lakh millions of plus millions of rupees. So this much at least during this time period in our study area, in our study context, the river is generating the resources. So then when we look at what is the problem here, the problem here it is when we look at the river resources utilization in basically what really I would like to mention here is that if we use the river resources the manner in which it gives or she gives, then this is we're not tampering with the resources, river resources. But when we really start modifying the river resources in order to exploit by enhancing the efforts of the economic agents, then they modify the river resources. When they modify the river resources, they can be at economically sustainable yield, maximum sustainable yield, total revenue equal to total cost, even economically not feasible, and critical decompensation. So if we look at the flow of river resources related to the livelihood, particularly in the context of cultural tourism, entertainment tourism, ferry services and fisheries. And then if we divide at least for the study area part, upper stretch, middle stretch and lower stretch, particularly middle stretch and lower stretch, the river resources, particularly the flow of the river, it is economically not feasible. So hence what we need to do. We need river space protection, resource conservation and livelihood promotion. In order to do that, we need to design incentives for the riverine people to harvest the resources at maximum sustainable yield. Then when we look at the what's going on in cities, particularly when we talk about resources, and we all know that cities develops master plans for land use, and this land use this particular map is really showing us master plan 1973 and master plan 2026, which developed in 2008. If we look at it, particularly yellow and pink color, pink colors. Pink color is hazardous industries, and yellow color is residential areas. And if we look at from 1973 to 2008 master plan, which it is applicable up to 2026, there is a lot of violations that the master plan violations occurred. So because of this, what the households in Chennai city, they are really facing the hazardous industries which are functioning in residential zones, contaminating the groundwater resources with heavy metals, cadmium, chromium, nickel, and lead. And this has a kind of implication to the tune of $50.1 million, $50.12 million per year US dollars as a drinking water expenditure. So and then so what's basically the problem? And we do have the master plans. It's systematically violated by hazardous industries, and that caused groundwater contamination. And the local water supply board may not be able to supply sufficient fresh water to the households, then there is a gap between the fresh water and the freshwater supply and the demand. That leads to the households informal water market purchase the water at high rates. Both water cans as well as the installation of water purifiers. So what we need to do? We need to design compatible land use regulations. So we need to divide the land use between the hazardous industries and the residential areas and strictly implementing them. In order to implementing them, there shall be incentive structured mechanism in the land use regulations. So then the other challenge which not only India, across the world we are facing is that while growing of the that really also leading to the CO2 emissions increase over the time period. So, in order to really reduce the CO2 emissions, we do have economic instruments, we do have legal rules, and we do have international conventions and conferences where India is signatories like Kyoto Protocol. And all these things works as a kind of after CO2 emissions generated, they want to try to reduce it. But so for each and every system, there is a limitation. So we really would like to try to really propose a kind of sustainable performance-oriented production practices as a kind of ex-ante approach. And this will put shoulder the responsibility on the CEOs of the polluting firms by really using the structured conduct performance paradigm. We mimic that and we develop this model. And then what is the problem? Again, the problem is in the regime, the World Trade Organization regime, where trade also a part of it, and the free flow of goods and services across the countries. And the technology really helped to migrate the labor, migrate the capital, and information communication technology and transport technology. So which all these things leading to the promotion of the trade. And because of this, it also enhances the income, but at the same time, the CO2 emissions also increasing. So what we would like to really do is that to adopt the sustainable performance-oriented production practices. So then, once after giving this kind of background specific, actually Indian with few preliminary studies, we simply look at theory. And when we talk about economics, economics is transformed from as a subject and which it also really the method and that as a method to efficient allocation of resources. If we look at this graph, as we have mentioned, the economic agents enhances their efforts in order to exploit the natural resources. When they really enhance their efforts, the stock of the resource decline. It is inversely related between efforts and the stock of the resource. So here, if you modify little modification, moderate modification, and high modification, it will have its own implications on the stock of the natural resources. Let us say if the effort is at e-profit, that is profit maximization, effort at profit maximization. Here the resources are abundant. That means the generating or the harvesting of resources less than the generating of resources. And when we talk about effort at maximum sustainable yield, the harvesting of resources equal to the generation of the resources. And when more and more people really looking at whatever the profit margin it is getting by exploitation of resources, more people joins. And then effort at open access, it is total cost equal to total revenue, no loss, no profit kind of thing. But with the state subsidies, then the people enhances their efforts. Then there is a possibility of efforts of maximum, and where the stock of the resources is at zero. And at times it goes depletion of the resources or extinct of the resources. So that will cause the impact of impact on physical, biological, and human management systems. So then, when we really look at the concept of the negative externality, so we simply really put it in a. I am not explaining this graph in negative externality. What I'd like to emphasize here it is in a very simple sense. The market prices is not telling the truth. It is omitting indirect costs of fossil fuel, such as the costs of climate change and treatment of respiratory illness and oil spills. So if we take an example, just as a hypothetical example, if the true cost of or true price of petrol per liter, if it is around 400 rupees, okay, but the market sells it at 100 rupees. If that statement is true, then we can call it as misleading accounting system. Just I'm giving this as an a hypothetical example. I am not betting for increasing the petrol prices per liter 400 rupees. No, please don't read my message in that manner. Then, when we talk about the pollution economics of mitigation of pollution, then we really talk about what are the damages because of the environmental degradation, and what are the damage costs and what are the abatement costs. When we talk about this graph, the marginal damage function curve reveals that how total environmental damages changes when we increase emissions by one more unit. That is one. And the most of the marginal damage function curves differs for a lot of reasons. One such reason could be two different substances. That is, curve A is more noxious than curve B. And then when we talk about the marginal abatement cost curve, what it indicates is that how much it would cost to me to go for one more unit of abatement of emissions. Conversely, how much I would save by reducing abatement by one unit and therefore increasing emissions by one. Then the equilibrium of marginal damage cost curve and marginal damage function curve and marginal, which it really is that marginal cost of abatement should be equal to the marginal benefit of averting the damages. At this equilibrium point, emissions are within the purview of the natural assimilative capacity or natural regenerative capacity. So the pollution here at this equilibrium point is not zero. However, the economists really suggest to go for zero if one unit of emissions generation really imposes huge damage costs. Then in such type of cases, economists suggest to go for zero emissions. One such we can really talk about is nuclear accidents. Then when we look at who bears the cost of pollution, is it the of a polluted product, or it is the consumer of the polluted product. So here we really simply take the concept of price elasticity of demand, and basically what we try to get out of this graph is that how the different demand curves affect the relative burden of environmental regulation shouldered between the producer and the consumer. When we talk about inelastic, producer surplus changes very little. Therefore, he has incentives to pass the full cost of environmental regulation to the consumers. On the other hand, when we talk about elastic demand, in such case, the producer surplus reduces very high. Hence, he will not pass the full cost of regulation to the consumers. So he will bear some of the cost of regulation. Then we are all aware of this voluntary bargaining force theorem, particularly talking about transaction costs. If the transaction costs are zero, then irrespective of who is having the property right, then I think the resources will move from lowest valued use to the highest valued use. So that is what basically the force theorem, and we can prove based on the true case Sturgis versus Bridgman. What's basically it says that if the bargaining is cooperative and involves zero transaction costs, it provides incentives to the parties to minimize their joint social costs of their activities. So I am not really explaining this case. If you want to, I think you can reach me later. Then other one is this tragedy of commons, basically Hardin's thing, which really talks about the common property resources. By the rational. But however, this theory, this concept contradicted by this who shared the Nobel Prize with Williamson. What she said, I think there is no, I think this, whatever this theory says, through her works, I think the people can manage the resources very well. So there is no need of too much of regulations. Then finally, what really we want, the aim is the sustainable development. We are not really only for economic growth and development, not only for environmentalism or conservation of resources thing, but we want to have economic development and environment. In this context, Brundtland, that report on Common Future 1987, that is meeting the needs of the present without compromising the ability of future generations to meet their own needs. So there are several definitions for sustainable development. In my opinion, this is one of the popular definition. That's why I'm using it. Then particularly then when we talk about the courts and pollution control boards, the courts in the context of, we can say it as a regulation is a kind of pollution control board. And when we talk about in a very nutshell sense, what this theory is really telling us, yeah. So the liability system is effective in providing incentives to the tortfeasor to take precautionary measures to reduce the risk of harm by setting the due level of care based on the case-by-case adjudication, generation of information from private parties, and decreasing of administrative costs, and error correction by way of appeals. And however, it has own limitations. In the case of award of damages, in the case of non-pecuniary costs, and also economic consequences of full damage compensation, over damage compensation, and under damage compensation. and then also the causational link problems and the loss delays. And similarly, the regulatory system, when we talk about it, is effective in providing incentives to the top officers to take precautionary measures to reduce the risk of harm by formulation of regulatory standards through scientific knowledge and collection of fines. However, it also has its own limitations in the case of regulatory capture and adverse effects in the case of formulation of standards for private goods. So the overlap between the liability system and regulatory system in terms of controlling of risk necessitates the use of these systems, optimal mix of these two systems. What do we mean by optimal mix of these two systems? That is basically the alternative legal system, optimal mix of alternative legal system is to be the one where the regulatory authorities set the standards minimum and the courts take these standards while awarding the damage compensation in the event of harm occurs. Similarly, minimum environmental standards prescribed by the regulatory agency may perhaps reduce the risk of harm, at least to some reasonable extent, if the liability system is unable to do so. Hence, the optimal mix of the liability and regulatory systems really work as a kind of substitutes and complementarities to each other. And when we really talk about the specifically the economic consequences of liabilities in the case of the full compensation, in the case of undercompensation, by looking what precisely the first graph, which it really level of care is set by the court equal to the efficient, and what it's going to be, what kind of incentives it's going to be in the case of negligence rule and strict liability rule. And when we look at the second graph, the bottom one, the case of undercompensation, here if the due level of care set by the court, which it is inefficient, which it is less than the efficient level of care. So in such case, how this negligence rule and then the strict liability rule will provide incentives to the wrongdoers. And in the case of strict liability rule, whenever the expected damages are higher than the expected compensation, then it always leads to distortion because of the profit maximizing care and then expected compensation will always lower than the optimal level of care, and vice versa. And in the case of negligence rule, when expected damages are higher than the expected compensation, it always leads to distortion because of the profit maximizing care and expected compensation again lower than the optimal level of care. However, it will not lead to distortion if the profit maximizing care and expected compensation is greater than the optimal level of care. So this information we can really would like to get from this graph. Then when we talk about the courts and the pollution control boards, an overview, it is a study which it is almost all 2 decades old. But however, we really look into it. What was the situation? Now, at least all of us can have a few observations whether the environmental quality improved in our country within the environmental within the purview of Environmental Protection Act 1996. I think we have really looked at the civil courts specifically the Supreme Court of India and the Andhra Pradesh High Court during this time period to see the public interest litigation original cases which were disposed by these respective courts. And we have the case data here. Largely, what finally we did is that whatever the cases filed, whatever the disposed, and under these courts, we really had a sometimes face-to-face interaction in large cases, large respondents, but very few the telephonic interaction. One is this information, and similarly, we also have done work on the pollution control board, particularly to getting the annual reports of the pollution control boards and the interaction with a few selected officials, and then critically examining the functioning of the three institutions to prevent the pollution and provide deterrent effect of the environmental degradation. So we really, when we look at the pending cases, specifically the case pending rate, it is always higher in Supreme Court to that of the AP High Court. Why? Because the AP High Court is really, whenever it receives the case or whenever it really would like to give some kind of favorable argument to the complainant, it simply calls the Central Pollution Control Board and asks the board state that is not central, sorry, it is not Central Pollution Control Board, it is AP State Pollution Control Board. The AP State High Court calls the AP State Pollution Control Board and asks to look into this matter. So in this way, the case disposal is very high, and as well as the consumers, the complainant's favor is also very high in the case of AP High Court and to that of the Supreme Court. Then this really reflects in the case of time taken to dispose the cases. In the case of disposal of the cases less than 180 days, both the institutions are the same. But when we talk about the institutions taking more than 1 year, in such case, Supreme Court is taking more time to that of the AP High Court, because the Supreme Court really gets the affidavit from the experts, and then it involves in a lot of arguments, and then it really try to give directions to the respective governments to really fulfill the purpose of Environmental Protection Act 1986. So we also whatever the data which we have, qualitative and quantitative data, we had an attempt to really look at so what is the success of the courts in enhancing the environmental quality. Then here we have very little information when we talk about it. One is if the courts dispose the case at shorter period of time, then this will give as a deterrent effect to the polluters not to pollute further. That is one clear-cut thing. And if the courts really give a very strict orders to the governments you have to implement the Environmental Protection Act provisions, and sometimes it monitors it also. If that kind of things are there, then again it will enhance the environmental quality in the country. So given this, we really look into the critical evaluation of the disposal of both cases in the light of theory of liability. we will take a couple of cases. One is, as we have mentioned, that of the courts, uh, the judges may be having really not aware of um, the technical know-how about the green technologies and about the wrong consequences of pollution. So it always need to depends upon the expert advice. And one such advice the Supreme Court it sought from in the case of Value Citizens Welfare Forum versus Union of others and Union of India and others. What basically the case is that in the North Arcot Ambedkar districts in Tamil Nadu, that district really consists of 450 tanneries, out of 50, 550 were located. And all these 450 tanneries, it is really, and this tanneries, whatever the effluents it comes out, it is polluting the Pollard River. So when this public interest litigation filed, the Supreme Court approached the expert agencies like Tamil Nadu Agricultural Research Center, Peace Trust, the Community Action for Development, hydrologist investigations. Again, they got from Tamil Nadu State Pollution Control Board and National Environmental Engineering Research Institute. And also they get the affidavits from the Central Pollution Control Board about the status of environmental quality in this area. And then based on the section 3 of the 3 of Environmental Protection Act, the Supreme Court simply imposed imposed fine for past pollution and also gave instructions to establish the ETPs. And at the same time, the new tanneries should not be allowed, and the old wells need to be replaced or relocated. So that is one thing where the judges require technical know-how from the experts. And second one is the ability of providing compensation for pain and suffering and other immaterial damages. The case is the Pollution Suffers Welfare Association and Government of Andhra Pradesh. This is the case where really it talks about the Hindustan zinc industrial pollution in and around villages of Visakhapatnam. There were 975 families really living in those villages for more than a century. And this, whatever the sludge coming out of this, whatever the pollution it is coming out of the plant, it is really what is that degrading the water resources and local wells, and it is unfit for human consumption and irrigation purposes. So there were really a lot of representations to the industry, but finally the industry really agreed to give 4 crore rupees to this 975 families in these villages to relocate. But these households, they have the sentimental value. This is our village, and we born here. We want to die here. We don't want to relocate. We don't want to shift. And by having this kind of sentimental value, then in the meantime, the industry closed, and they haven't even get it the 4 crore. So that means neither they're taken into consideration of the environmental damages for the humans, even nor the ecological depletion and degradation. So then when we talk about we usually think that when we use the appeals, it is a kind of error correction mechanism. That means if the lower court judges, whatever may be the reasons, if there is any kind of biased judgment, then we move from district to high court to Supreme Court, and Supreme Court single bench to multiple judge bench kind of thing. And by that, we correct the errors if there is any error in the orders. But the polluting industries, they take these appeals as a kind of instrument in order to, as a delay tactics, in order to be in the participate in the activities of pollution generation and accumulation. And one such thing is that this is basically when we talk about error, the appeals as a kind of error, we really want in a brief nutshell sense, what is this case? This is basically Jayant Vitamins Ltd, which it produces vitamin C in Madhya Pradesh, Ratlam. And this Ratlam people, they get water, households, they get water resources from river Pural. Because of this giant vitamins and some other polluting industries in that place, really the drinking water resources really polluted. It really started starting producing vitamin C in 1975. Whatever going through the getting licenses from pollution, respective the pollution control board. But there were cases, several cases from 1975 to 1995, almost all 20 years. This industry used the appeals mechanism, and it stayed in the pollution activities almost all 20 years. And even after 20 years, the Supreme Court simply sent this case to the Madhya Pradesh State High Court because the Madhya Pradesh State High Court can monitor this case because the environmental problem occurring in MP, so it can monitor well than by the Supreme Court. Then other one is the problems involved in implementation of the orders. This is one in AP High Court, which it is really, it is a neighborhood effect kind of thing. There is a household unit, which it is really wet and dry grinders, and that generates noise pollution and air pollution. And the neighborhood will all the time close the doors, switch on the lights, no ventilation, and noise pollution. And when they complain, and the AP High Court called the AP State Pollution Control Board to look into the matter. And the complainant visited the AP State Pollution Control Board 20 to 30 times. What's happening? Why you are not taking action? Court already gave you the order. And at the 30th time, the official who really interacted with him said, we have lost the file. Then he filed the contempt case. Then the Pollution Control Board started taking action by disconnecting the power, disconnecting the water supply. But still again, they really, the wrongdoer really have an influenced person. And instead of two phases, he started functioning of this unit with one phase electricity supply. Then really when we talk about involvement of lawyers, here in a very nutshell sense, what I would like to say is that the complainant will hire the lawyer, and the opponent also hire the lawyer. And if there is a nexus between the lawyers, most of the times the complainant lawyer will really what is that whatever he I think he can take some kind of bribe or whatever it is from the polluter side, and then he can really, what is that, not to give good services to the complainant, so that the complainant will lose the case. So there is a such kind of experiences we have come across. Um, yeah, this is a fact, and we have to see whether it is true even these days. Then, based on whatever we have got the thing, a few suggestion is the judge's spot visit. What basically means, um, if the environmental degradation is really imposing huge harm in the society. Around 82% of the respondents, 81% of the respondents, really they really want the judges need to be visit the environmental degradations spot. Then they themselves can witness it, and once they witness, it will be helpful for them to really give a unbiased judgment. That is one thing. And second one is that which there is some at times the problem of legal aid. I think all the complainants may not be rich in order to meet the expenses of the court cases. When we talk about reaching the Supreme Court in public interest litigation, a household who is staying in Kanyakumari, it will always have the expenses. And the legal aid, when any person really giving the services under legal aid, if he is doing the social work, then no issues. But if the lawyers are for money, and their services are available only for money, then I doubt it whether the complainants will get the justice for in environmental degradation cases. Then other one is the establishment of separate environmental protection courts. This is not the new idea of out of this study. The N.D. Tiwari in 1985, when the Congress government was in power, set the committee, and one of the committee recommendation is to establish a separate environmental protection courts. But the government hasn't done that. And this, when we did this study during this time period, 1999, again, large percentage of respondents really favored a separate environmental protection court. And the third reason is also is that Article 32, which we can file the writ petition in Supreme Court, and Article 22 to 6 of the Constitution, which we can file PIL in high courts. When we file this thing, the judgments can be given. They can give directions to the state governments to really take the remedial measures under sections 3 and 5 of the Environmental Protection Act 1986. So the compensation to be given to the victims of the pollution, just we need to look into it, whether can we really have that provision into it or not, that need to be looked into it. So hence, from 1985 till 2010, we haven't done that separate environmental protection courts in this country. Only in 2010, the National Green Tribunals were established. So it took almost all 25 years. Then the contempt of court orders. So when the court give directions to the state governments to implement the sections of the Environmental Protection Act 1986, some of the officials, they really won't implement it. And when they won't implement it, if the court issues the contempt of court order, then the officials, if they simply say a simple reasons that we don't have enough resources and the officer who was here transferred, and if any kind of simple reasons, the court really don't want to send the top level officers behind the boss. Maybe rarest of the rare case they do that. So by I think if the courts are not straight, not implementing the court orders, then it's a kind of lenience so that the polluters will be in the pollution activities and the environmental quality degrades in this country. Then the last one is the accountability of judiciary, legislative, and executive. It is really they need to work hand in hand in order to enhance the environmental quality in this country. But at times they may have conflicts, and when they have conflicts, then yeah, it will have its own consequences about it. So hence, I think there is in my opinion, there is a need for apex body, and that apex body will have a special structure and functional and legalities. This apex body can be the public interest, what is that, oriented members. So if we can choose those kind of excellent people from these three constitutional functionaries and establish apex body, and that apex body only interest is to enhance the environmental quality at the interest of the public, to that of the mighty, rich, and power-centered people. So this is what, when we want to talk about the court-based review, I will take, how much time it is left, please? Could you tell me? Hello?
Sir,
Hello?
sir, am I audible?
Yes.
Sir, we were to start the next session by 5, but we are running 15 minutes late. So you can take up a couple of minutes.
Who is speaking, please?
Sir, I'm Shubhi.
Pardon?
Sir, I'm Shubhi. I'm hosting the event.
Yeah, but at the same time, it hasn't also not started at 4.
Yes, sir. Yes, sir. You can take your time, sir. There's no problem with that.
No, that is not the thing. If that is the case, I just browse through the slides and then I stop it. So basically what we really look into that the Pollution Control Board is as a preventive mechanism. But when we look at the Central Pollution Control Board activities and the State Pollution Control Board of Andhra Pradesh activities, there is some kind of issues related to the human capital. I think this kind of boards should have more of scientific and staff to that of the administrative staff. But if we look at this graph, administrative staff is much more than the technical and scientific staff. So then when we talk about income and expenditure, initially they get funding from the states, governments, but over the time period, the government's resources reduced. And some of the pollution control boards, they need to generate their own resources through water cess and by collection of consent fee, and consent for establishment. And then whatever the consultants work they do, most of the money they want to put it in the bank account as a deposit rather than completely using the financial resources. This is what the AP Pollution Control Board issuing of consent for establishment and consent for yeah, water cess and the closure orders. It is really, I think there is some kind of lacuna in the functioning of the pollution control boards. as I mentioned, in the case of Andhra Pradesh Pollution Control Board, in a given year, it has generated 10.9 crores. Out of 10.9 crores, 10.6 crores it has generated from what is that collection of the consent, large percentage consent of giving permissions for consent for operation and consent for establishment. So that means they are giving very leniently the licenses. So that is what I mean. Then there are certain things which we need to talk about in a very brief sense. If you look at this graph, I picked it up from one of the AP Pollution Control Board. It itself states that in combined Andhra Pradesh, now it is divided Telangana and Andhra Pradesh. This map is combined Andhra Pradesh state because study between 1990 and 1999. These are the hotspots of environmental degradation. And what basically my question to one of the official, look, this this pollution control boards were established at least 25 years back, and the taxpayers really at least to would like to look into it, that even though you won't increase the environmental quality, but your presence should not decrease the environmental quality, or even you are not maintaining the environment. When I posed this question, the official said that because of the presence of this pollution control boards, it is just increasing some percentage, not huge percentage. So that is increasing in the sense that is environmental quality degradation increasing is a little percentage, not too much. That means it is maybe 100%, not 200%. That kind of answers we got it. Then another one, we are also know about the Constitution of India, Article 51 AG, the fundamental duties of each and every citizen of India. And if the pollution control boards are not providing information about the rogue industries, then how the households really boycott the polluted products of these rogue industries? When I asked this question, then one official informed me that if we disclose it, then the public will panic. So hence we won't disclose it. So there are certain things which it is really the issues. And one is, I think I don't know what is now the financial situations of the pollution control boards. And it should not, I think, in my opinion, the financial support should come from consolidated fund. So there shall not be any issues of financial resources while it really work for prevention of the pollution in our country. And another one which we would like to also say that the basic thing is that when you give licenses, when you monitor the licenses, you need to really test. We need to monitor whether the polluting firms are in compliance with the environmental protection legislation or not. And sometimes they need to go to the premises of the polluting firms, collect the samples and test in the lab. And if they deviate from the standards, and they need to give the disclosure, they need to order the closure orders, like connection of water supply and disconnection of water supply and disconnection of electricity supply. But there is a sometimes nexus between the pollution control board officials and the polluters. Before they go, they get the information from the pollution control board. We are visiting you such and such time. So the polluting firm really switch off everything. And by the time they reach and collect the samples, it is not much impact. That is one. And second, if they need to collect water samples, this pollution control board officials go during the floods time period. And when they collect the water samples and test in the lab, it is again within the permissible limits of it. So this kind of observation which we had during the study. So honestly, I don't know what's going on. This is 22 decades back study, and we need to really look into it. What is now the pollution control boards and the judiciary is now the Green Tribunal, National Green Tribunal is really protecting the environment in our country. Then the conclusion part is when we look at it, the Sustainable Development Goals, in order to enhance the quality of life, basically we need to look into the design of incentive structure, structured institutions for the economic agents to change the behavior, to enhance the performance of the rupee within the purview of ecosystem services. So what I mean to say is that our currency value, the rupee value, should also have a component of environmental attributes. The manner in which when we want to buy a house, we really have a, whether we want to buy a house next to the botanical garden or next to the filthy land filling site. So when the environmental attributes as part and parcel of the housing thing, housing market, in the similar sense, the rupee also should have the environmental attributes component when we really give value a kind of rupee. And if one more point, I will stop it here. When we talk about global warming, climate change, we can also really look into the Kyoto Protocol kind of thing. Why the North-South countries conflict? Why the countries are not really coming forward in order to truly reduce the CO2 emissions in spite of whatever the physical, biological, and human management systems occurring across the countries. Why can't we really change the exchange rate instead of some measures? We also really look into the ecological footprint of a given nation. We also need to look into the stock of the environmental goods and services, both landlocked and maritime resources. So why can't we bring that element also in really what is the currency values of the nations? So whether it will have some kind of impact on reduction of CO2 emissions. That is what it is, and I'm sorry for taking more time than given by the organizers. Thank you very much for providing me this opportunity. And if there are any questions, and please send it to my mail ID, and that mail ID is with the organizers. Thank you very much. Thank you.
Thank you so much, sir. Thank you so much for your informative session.
Yeah, thanks a lot. I think we skipped the question and answer session. Can I log out, please?
Yes, sir. Thank you. I will share your email ID and I'll send the questions across to you. Thank you so much, sir.
Yeah, thank you.
For our fourth session today, we are pleased to have Professor Dr. Vishwanath Pillai, who is currently with the Indian Institute of Management, Ahmedabad, in the Economics Department. With over a decade of experience in the multidisciplinary field of law and economics, he has, under his belt, a variety of publications and research in the field of microeconomics, applied economics, behavioral and regulatory economics, and much more. We are quite grateful to.
Hi, thank you very much for having me over for such an interesting conference. If you guys want to take a few minutes break, I'm okay with that, by the way. We can start at 5:30, but it's up to the organizers. I'm not going to, yeah. Hello.
Professor, good evening.
Hi, Ranita. Go ahead. Yeah, go ahead.
I think we'll continue. I think we'll
continue.
Please,
okay,
please.
Perfect. I have absolutely no issues either way.
Yeah, thank you.
Okay, so let me share my screen quickly. I See, let me start with a small disclaimer, please. For a management professor, I hate teaching using slides, but and I also am, I believe, within striking distance of GNLU right now. So maybe perhaps I could have actually dropped by to give a talk. I really hate using slides, but I think in this digital world, probably everything is digitized. So therefore the talks are also digitized. So I made some, for the lack of better word, extremely crude slides on how I was going to structure my thoughts, just to give it a bit of a, articulation. I just had a few slides. So let me quickly share my screen. You got to excuse the crudeness with which they're being presented, because as I said, I really didn't intend to use this, but in the last minute, maybe having something will be good. Okay, can you all see my screen? Okay, so let me start out. What am I going to talk about today? I'm going to talk about the mixture of three distinct disciplines, which I've always found very fascinating in my day-to-day work. The first discipline is what gives me bread, what keeps the kitchen going in my house, as they say. The economics, microeconomics to be more specific. Then the second one is something that I had practiced for a while, law. While I had actually done, quite a bit of work as a consultant in the competition law, I have developed a bit of a fascination for law and lawyers in general. So therefore, that's another aspect. And the third aspect is this classical tussle that people keep talking about, psychology. Okay, so I'm not claiming that I have any great expertise in either law or psychology, but I do have a bit of expertise in economics, and I did spend a lot of time thinking about law and psychology. So therefore, my main thought today is for you to basically understand the interface between these three wonderful subjects, microeconomics in particular, law and psychology. I mean, so this is exactly what I'm going to do. What am I going to do as a reason is that I want to bring out a tussle. What is this tussle? As lawyers, you're trained in this argument of logic-based decision making. When you go and sit in MBA class too, I think these guys are all trained about, very structured decision making, blah, 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 blah. We call these guys, I mean, the economists have a very interesting name for these guys. They're called Homo economicus. This extremely newly evolved species, which basically is somebody who is completely rational, does everything with selfish interest at heart, blah, 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 blah. On the other hand, what we have is what we call as Homo sapiens. We are human beings after all. We are governed by our own set of idiosyncrasies. We are governed by our own set of, by our own set of emotions in decision making, etc., etc. So to me, this entire workshop is this entire session that I have, 45 minutes of time that I actually have, is a tussle between these in two people. One, the Homo economicus, the other one, the Homo sapien. Okay, the logical versus illogical, and where does it fit in as far as lawyers are concerned? Let me start out with a very interesting game, which we call as the ultimatum. The ultimatum game has a proposer. Let's call this guy A, and there's a respondent. We call them as B. Imagine these two people are playing a game together, and let me describe the game to you. Yeah. Somebody gave 100 rupees, let's say, to A, and said, A gets to decide. What does A get to decide? A decides how much of rupees 100 will he/she share with B. Okay. What does B get to decide? B gets to decide accept or reject. What does accept mean? Accept means that proposal of A goes through. And reject means both of them get 0. Let's think about what one Mr. Spock, I don't know how many of you follow Star Trek, but if you did, you know, Spock is the epitome of emotionless decision making. Captain Spock is the epitome of emotionless decision making. If Spock were to be looking at this game, if an economist were to be looking at this game, it's obvious. Now, a person is better off with 1 rupee than with nothing, right? So therefore, A should be offering B $1, and B should be saying yes. B should be grateful to A that A has given him or her $1, and B better accepted. Now, this is a game, this ultimatum game has been subject to a lot of experiments throughout in the history of economics literature, right? Homo economicus is very clear. Homo economics B will accept 1 rupee because 1 rupee is better than nothing. And Homo economicus A will know that B is absolutely happy with a rupee. So therefore, why should I give anything more than a rupee? They will give you out that 1 rupee. The important question in this particular case is, how does a Homo sapien behave? And what does this game got to do with the legal field? Okay. I'll come to that second part of my question a little later. What does this game got to do? What has this game got to do with legal field? I'll come to that in a few minutes. But essentially, how does a Homo sapien behave? And I think studies have shown that it is diametrically opposite to what Homo economicus is supposed to do. For example, many of the people, I mean, imagine you put yourself in the shoes of B and somebody's offered you 1 rupee out of 100. You're more likely to say what? I mean, go to hell with all these nonsense. I don't want any money from you, but I'd rather make sure that you get nothing out of it. You get nothing out of it. So therefore, what is likely to happen? This negotiation between A and B is likely to fail when the stakes are very low. Okay. So that's exactly what somebody thought. I mean, somebody said, okay, of course, B is going to reject it because the stakes are very low. Why would somebody care about 1 rupee? But if I were to say, huge stake sizes, what is likely to happen? Will the negotiations go through? Will what Homo economicus say work out or not? That's a question. So what did these people do then? I mean, it's a bunch of researchers. What did they do? They showed up in rural Tamil Nadu, Madurai district to be more precise, and made stake sizes 5,000 rupees. You can imagine, to a person who is earning close to 2,000 rupees a month, 2,000 to 3,000 rupees a month, this is a huge amount of money. Even here, experimental evidence seems to be extremely clear. People were offering at least 30% of the pot size for, to the respondent, and respondents were rejecting anything less than that, despite the fact that this money could have made them substantially richer. Now, what is the whole argument that is working out in this particular case? What is the whole argument that is working out in this particular case? People have an innate sense of fairness. And generally, when they perceive things to be unfair, they reject it. Okay. I would actually call it as perceived sense of fairness. No, they reject it. Right? Let's look at a variant of this particular example. Let's look at the variant of this example so that everyone's clear. Now, in this case, the experimenter has asked both proposers and the responders to bring 5 rupees each or 50 rupees each. Okay. In this particular case, 100 rupees is put. And the proposer is asked to propose how much of the 100 rupees he or she wants to split with responder. Who the proposer is, who the responder is decided by drawing lots. Nobody knows about each other. You can't see each other. Now imagine suddenly in that particular case, what's likely to happen? It turns out that many responders chose to lose 50 rupees than gain anything less than 50 rupees. Do I make sense? So if a proposal were anything less than 50 rupees and you reject it, money goes to the experimenter, no? Even in that particular case, people have decided to forego that 40 rupees or 50 rupees. What does Homo sapiens, Homo economicus do? The Homo economicus would think about the 50 rupees as sunk cost and basically learn to ignore it and take whatever comes his or her way. The difference between the first experiment and the second experiment in the neoclassical economics should not be different from each other. But in real life, what you notice is exactly this. There is difference. If the stake is not split exactly half and half, people get mad. People get mad. A version of this experiment. You put in 50 rupees, I put in 50 rupees, just for the sake of argument, imagine I'm the proposer and you're the responder. Experimenter adds another 100 rupees. So total stake sizes become 200 rupees. And I'm asked to propose an amount to you to split. Make sense? Now, in this particular case, if I offered you anything less than 60 rupees or 70 rupees, the bids are rejected. Despite knowing the fully well that if you reject it, you will lose your 50 rupees as well. Many people have rejected this particular bid. Now, many economists will call this sunk cost fallacy. People will argue many business decisions involve ignoring sunk costs. But people don't ignore the sunk costs. People are very clear that they'd like to lose that money than get an unfair offer. Do it make sense? Let me describe another experiment that a colleague of mine and I conducted at one of the local colleges in Ahmedabad. We gave very unfair offers to participants. But nonetheless, half the participants actually were holding money in their hands when they were making decisions. Half the other participants actually did not have money in their hands when they were making their decisions. Right? It turns out that the difference between both of them is nil. Almost every business negotiation class, first thing they tell you is cash is king, and when you put cash on the table, negotiations go through. No, in this case, I don't think we were observing that at all. We're going to publish that paper shortly. But nonetheless, I think not just our study, there are quite a few studies that we figured out as a part of our lit review. We figured out that people actually reject unfair offers. Now comes the next part of it, religious and political backgrounds. I think there are enough studies that have shown that people actually have changed behavior in the ultimatum game, depending on their political backgrounds, depending on their religion background, etc., etc., etc. One of the interesting studies which an exchange student of mine conducted was to ask himself a question. Economists are always thought to be selfish. Would economists actually have a different way of behaving in this when compared to other disciplines? What are the other disciplines that he has chosen? One is econ, another is, he said, lawyers. Third one is sociologists. Why did he choose these three disciplines? His argument is economists are taught to be selfish. They will end up offering low amounts. Lawyers are all about making deals. So therefore, they would offer slightly higher amount. And sociologists are all about equality and everything else. So therefore, they will offer greater amounts to the opponents. It turns out that this experiment was conducted by my student in Bocconi in Italy. And it turns out that his prediction was spot on. Economists offered the least amount of money as proposers with other people. So you see the religious political backgrounds. I mean, one of the very interesting studies that I've come across in this was actually conduct this experiment on erstwhile communist countries. There's a generational divide on how proposers actually behave. Why am I saying this? Why is it important sometimes that we need to know this? In a communist world, people have been talked to forever on sharing of resources. They ended up being better proposers. In the post-communist era, for example, this experiment was conducted in Yugoslavian states and SSRs of USSR, right? And it turns out that the older generation ended up offering greater amount of money than the newer generation did. So what has law got to do in all these cases? One of the fundamental arguments that that lawyers are taught to deal with all the time is this sense of negotiations. Why do negotiations fail? This is a question that I keep asking myself. Why do negotiations fail even when there is a win-win situation that is present? financially speaking, strictly financially speaking, a responder saying yes is a win-win situation for both of them. But no, the innate sense of fairness that people have had, which is so inbuilt in our psyche, does not allow the win-win situation to come through. So what's a fundamental lesson that a behavioral economics teaches us? When you go to a negotiation table, it's not just sufficient that you're fair. It is important for you to be perceived as fair. It's important for your offer to be perceived as fair. My previous speaker was talking about environment, and several people have talked about environment and all that stuff. Why do environment negotiations keep failing? That's a fundamental question that we need to ask ourselves. And it turns out that the innate sense of fairness with which I deal with, with the stake size that is out there for consideration, and the innate fairness with which you deal with stake size, completely different. Now, any basic organizational dynamic story will tell you the following. You need to be able to understand multiple perspectives in order to arrive at a decision. I actually disagree. It's not sufficient to understand multiple perspectives. It is important to understand the multiple perspectives specifically on the point of fairness. Fairness is a fundamental argument that every human being suffers from. The only species that is completely that has a complete clarity on what fairness is a Homo economicus, not a Homo sapien. The idea of fairness, this is what I want to point out, which is where lots of legal studies are predicated upon, is highly context dependent. Fairness, a fundamental argument in philosophy which drives a legal policy in some sense, is this argument of fairness. Jeremy Bentham takes the utilitarian view, whereas John Rawls takes a societal view, and a bunch of philosophers talk about a bunch of different ways of this argument of what is fair. There's no objective definition of fairness, but there is one particular argument of fairness, but one argument that is very clear. It's highly context dependent. And what does behavioral economics tell us? It tells us that the cold-headed logic with which certain decisions are taken are not necessarily agreeable. So that's the first point I want to put on the table. Right? The ultimatum game and the reason why negotiations fail. Coase theorem, for example. Coase theorem is very clear. If you define the fundamental arguments of property laws, property rights, I'm sure all of you have heard about Coase theorem. Ronald Coase, the Nobel laureate, Coase theorem. If there are no transaction costs and if property rights are well defined, then the fundamental, what is socially best will have to come through. The question is if the argument that many people have addressed, and I'm particularly referring to a very interesting paper that I came across by Sunstein, Thaler, and Jolls. It Cass Sunstein, Richard Thaler, and Jolls, Christina Jolls, I think. The argument that they make is Coase theorem fails. When does Coase theorem fail? When the property rights itself are deemed to be unfair, Coase theorem fails. Just as the socially optimal outcome in an ultimatum game has failed because the participants are deeming to think that the distribution of wealth that you actually have is fairly unfair between the people. So this is the first point that I wanted to talk about based on some of the research that I did and based on some of the research that I have actually read. The second argument that I want to come up with is anchoring. Why does anchoring work? And I'll spend some time worrying about the lawmakers this time. This is not about lawyers anymore. This is more about lawmakers. Since the session is about law, I interpreted broadly lawyers as well as lawmakers. So this is exactly what I'm going to do. I'm going to give you a bit of an understanding of some of the papers that I've been writing in the recent past, which are under review at a couple of very big journals. And I'd like for you to understand this argument of anchoring. There is something that I actually play as a game in a physical class. And I love this game. What do? I divide my class into two halves. They don't know that they're being divided. And I circulate a questionnaire to them. What does the first questionnaire have? The first questionnaire would have a couple of innocuous questions. For example, do you know who the man of the match was in yesterday's India-England test match? Second question, who do you think won the maximum number of medals in the recently concluded Olympics? Most answers I get is I really don't care. Not everyone's a nut job like you in dealing with sports. I really don't care. Fair enough. The fourth question that I typically ask them is, for half of the class, I give them a number 105. And I say, can you think of 3 objects? Can you think of 3 objects that would actually, that you could buy with 105? This is a replication of a very famous experiment conducted by Dan Ariely to the students of MIT of nonetheless, right? MIT Sloan School. I'll describe that experiment in a few minutes, but let me talk about mine. Okay, obviously I love my experiments. Right, so for one half it's 105. For the second half it's 995. I ask them to think about 3 objects that they can buy with this money. First group is being asked 105. What are the various items that you could buy for 105? What are the various things that I get? A small bag of rice, a pack of biscuits, notebook, pen, pencil, pencil box, a small water bottle, blah 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 blah. For 995, things move to a higher level. Bluetooth headset, a pen drive. Somebody mentioned a nice bottle of wine. I think, if you're in a virtual class and you're not necessarily in a dry state when you're attending the class, I don't know what laws bother them. So therefore, let them indulge. I mean, whatever, right? A nice bottle of wine. Lots of very interesting choices. At the end of it, I actually take a coffee mug and I auction it off. Coffee mug would have a nice IIM Ahmedabad logo on it. I can even show you. Coffee mug will look something like this. It has a facade of IIM Ahmedabad on it, etc., etc. Underneath it, there's typically my signature and all that stuff, and I auction it off. It turns out that the group that have actually thought about pencils and notebooks and a small bag of rice end up actually giving me 400 rupees on an average for that coffee mug. Group 2, which is thinking about headset and all that stuff, ended up giving me 995. Ended up giving me on an average around 800 rupees for coffee mug. What has your ability to think about notebook versus Bluetooth headset got anything to do with valuation of the coffee mug with my humble signature or not so humble signature on it? Very interesting, but it does play a role. The idea that you are exposed to before you reach the negotiation table, the numbers that you've been exposed to before you reach the negotiation table, end up having an influence on what you think is right. I'm sure all of you have come across Bata, a very famous shoe company. There is a concept in marketing, it's called Bata pricing. Why? The price always is 995 rupees. Why is the price 995 rupees? I think the consumers are very clear. The consumers are typically anchored in their minds to the first 2 digits of the price that they see. 995 is 900. 1001 is 1000. So therefore, the difference between 995 and 1001 is not 6 rupees. The difference between 995 and 1001 is close to 120 rupees, 125 rupees. That's the whole argument that I want to bring to the table. This is the idea of anchoring. We see anchoring actually happening in several cases, and I'm going to apply this argument of anchoring to a very interesting experiment that we did. We showed up at Ahmedabad University BBA class one day, and we basically asked a bunch of undergrad students, the final year BBA students, to solve a maths question paper, high school maths question paper. We had a bunch of maths problems in it. And we said, we will pay you $50 for every right answer that you actually get. Okay, so IIM Ahmedabad professors in an undergrad college giving maths exams. There's only one thought in most people's minds. These guys are here to tell me some tips about CAT. People showed up, students showed up. Just because they showed up, we gave them $100. Okay, so if you're wondering why we need research money to conduct research, this is the reason why we need tons of money so that we can distribute freely among people and all that stuff. I'm kidding about the that part, obviously, but nonetheless, research is costly. Okay, so what happened in that particular case? What happened in that particular case? At the end of them solving 10 questions, we paid them their money. Whatever they've earned, 100 rupees for showing up plus 50 rupees for every right answer. We said, if you want to donate any percentage of your money, these are all 19 years old. Some of you may actually be that, 19, 20 years old. Correct? If you want to donate any amount of money to charity, please feel free. So, in the next class, we did something slightly interesting. We went to the class and we said, okay, maths questions, you get your money. But here is what we ended up saying. 5% to aapko dena hai. You know, whatever you earned, 5% of it, we deducted before we give it to you. Okay? You don't have a choice of not paying, not getting that kind of a money. Right? But rest of it will be paid to you. If you want to donate on top of it for charitable causes, feel free to do so. Feel free to do so. Turns out, as you can figure out, treatment one is you don't have to pay anything. You can walk away with your money if you want. And treatment two, you have to pay 5%. It turns out that, you know, in the first group where there is no contribution at all, you actually had 83 rupees, which is roughly around 39%. But when we insisted that we cut 5%, so here is a group that was willing to give 39% of their earnings. It makes you feel great about the youth of India today. You feel that they're really selfless. But the moment I tell them that you have to give 5%, Homo sapien, Homo economicus would say 5% shouldn't matter. Why? Here is a group that's willing to contribute close to 40%. Why do I care about 5%? But the moment I put that 5% out, turns out the charitable contributions actually fell down to 24.9. And more interestingly, you see that the standard deviation itself went down. I think I got the symbol wrong, greater than symbol wrong. Actually, it should be other way around. But yeah, I told you already, I was quick in doing these lines. You get the picture of where I'm going with this. When you insist on certain minimum participation, you know that people are going to stick to that minimum participation. It's a very interesting insight that we actually got. We ended up applying this to the 2% CSR law that the government has come up with. And that paper currently is under review at an international journal. We've written a large paper with it, but essentially the argument is Homo economicus does not care about the 2% law. Homo sapien does. What happened in the follow-up of this experiment, I'll tell you. We came back to IIM Ahmedabad. We don't want to trust undergrads. No offense, but nobody trusts undergrads too much in terms of their decision-making capabilities. We experimented this with several executives that come to us for training. I mean, I do a lot of executive training, and I end up teaching a lot of people in the corporate who end up making decisions. We created a fake balance sheet for the company. We ended up creating profit and loss statement, and we asked them the question. The moment 2% CSR law is mentioned, you never see contributions go above 2%. Most often than not, they're significantly. There are lots of theories to explain it, like anchoring, organizational dormancy, blah, blah, blah. I don't want to go down that route. But the main point I want to tell you, which is very important, is that the 2% does have a role to play on how companies spend their CSR money. And I think to me, it's a very salient issue. Right. So let me actually continue a little bit more, in terms of, why I'm talking about anchor. Where do I tie it up with law? Obviously the 2% CSR law is a very interesting law in my opinion, and I'm really desperately looking every year after year, updating my data set to figure out how the 2% law is panning out in the real life, and all that stuff. But here is where I think as students, you need to know, what are various kinds of influencers of human behavior? Is it just the money that is anchor? Is it just the numbers that are an anchor? Let me talk about the original experiment before I go into the deviations, right? The original experiment was by Dan Ariely, where he auctioned off 5-6 items. Before you get to participate in the auction, you're supposed to do something very simple. You're supposed to write down the last 2 digits of your social security number. Social security number would be equivalent to the Aadhaar number in the US, and put a $ in front of it. Then you're supposed to submit your bids for how much you want to bid for various miscellaneous items. Correct? And it turns out that people whose social security number was ending in 90s ended up outbidding the rest of the folks when compared to those fellas whose social security number is ending with 20s. Do I make sense? So this is where they show the anchoring part. But here is where I'm going to come up and tie it up with other versions of law that you actually see, which are very important in my opinion. Numbers are not the only anchors, by the way. Numbers are not the only. It turns out that the experimenters at one point in time wanted to understand a few things. Can statements be anchors? Can stereotypes be anchors? Here is where an interesting part of the law comes out. So what did they do? There are 2 stereotypes that I know of in US. Having spent 9 years in the US, there are 2 stereotypes. Stereotype 1 is that men are good with maths. This is nonsense, but yeah, that stereotype does exist. I still have a friend, a 70-year-old lady, and she would tell me that she was encouraged as a child to learn Spanish. Her brother was encouraged to learn German. Why? Well, ladka hai, he'll do science, so he should know German because knowledge is there in Germany and US, so therefore he learns German. She learned Spanish because yeah, ladki hai, school teacher banegi. So US Spanish is the second most spoken language in the US. ठीक है, so fair, good to learn Spanish. So that's a stereotype that exists. I don't believe in it, but it does exist. What is the second stereotype that exists in the US? The second stereotype is even more interesting. Asians are great with maths. Indians, Chinese, Vietnamese, Koreans, they're all supposed to be great with maths. In fact, actually, I know this as a stereotype completely. Okay? I've experienced this significantly. Oh, you're from India, you should be good at maths. Why should I be good at maths if I were doing my PhD in English literature? Incidentally, yes, I do have an advanced degree in mathematics and I'm fairly decent at it. But not because I'm an Indian, but that's because I'm interested in maths. I mean, if I were from English literature, I don't know why I should be interested in mathematics, for example. Nonetheless, that's a stereotype. So what did these guys do? They assembled a bunch of Asian American girls into a single room. And unbeknownst to these girls, they were divided into 3 groups. Group 1 were asked the following questions. Group 1 were asked nothing. So group 1 is our control group. Group 2 is what I call as Asian treatment. Okay. What is this Asian treatment about? The girls were asked a lot of questions about the fact that they were Asians. What language do you speak at home? If it's not English, how do you adjust to the American life? What language do they speak? Do your grandparents speak? Everything pointed out to these girls that they were Asians. What is G3? G3 is what I call this as woman treatment. A bunch of questions only women in the world get asked, no man ever gets asked. What is work-life balance in your view? How do you intend to take care of your children when you're working? Blah, 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 blah. All the questions that point out to the womenhood. Then, after the questions were asked and answered, these guys ended up going and giving a test. Maths test. Simple maths test. Average scores come out. It turns out that G2 performed the best, followed by G1, followed by G3. Now, here is the deal that I want you to think about. What is the whole argument about the modern view of the legal literature that is all about fairness across various social groups? What is the legal precedent? Imagine this. Just spend some time on the result that I had actually charted for you here. References are all available. I'm not making up any story out here. Every statement I made is backed up by a research study. Made sense? What is it? The gender stereotype that you're talking about ends up affecting the performance of people here. Very interesting. Homo economicus doesn't care. Homo economicus simply does not care. Homo sapien, on the other hand, is swayed by this entire argument, a tussle between what she had gone through earlier before she had come to performance stable. Now, why are Sardarji jokes not okay? No problem in admitting here that at one point in my life, I always thought those jokes were cool. Why don't I anymore? Because to me, it's no longer funny, actually, because it starts affecting the performance of people ultimately. Right? You're not talking about sentimental value, but Homo economicus does not care. Homo sapien cares. Here's another example for you as far as anchoring is concerned. Okay. People were asked, bunch of kids were asked to make sentences with words. Group 1 was asked to make sentences with the words like peaceful, calm, serene, balanced, equanimity, etc., etc. Group 2 were asked to make sentences with words like rage, anger, seething, bunch of those words that show that you're mentally charged up. Turns out that they were all put in a group task, and an experimenter who is disguised as one of the participants keep making mistakes in a group task. Fellows who shouted at this experimenter were the ones who made words about seething and rage. People who kept calm are the ones who actually made words about calm. So this is where anchoring comes. Anchoring is not a number, anchoring is a concept. Do I make sense? When we are thinking about laws, we assume a logical position, and our logical position has no role to play as far as emotions are concerned. When we are looking at laws, even lawyers are not subject to emotionless decision making. Trust me when I say this. I've made quite a few lawyers fools by this anchoring experiment. Bureaucrats are not fools either. Last time I taught these sessions, I had Indian Foreign Service, senior Indian Foreign Service officers as my students. They fell hook, line, and sinker to the anchoring experiment that I talked about. Homo economicus does not care. Homo sapien, on the other hand, cares. When you, as a lawyer, go to a negotiation table, you know that as much as logic is present, it is the emotional response that you need to be worried about. And this, ladies and gentlemen, is where a number that you go to negotiations table with is economics. The entire tactics, in some sense, are legal. How you present your facts is psychology. And this is where, ladies and gentlemen, the eternal struggle between Captain Spock and Homer Simpson will continue to exist. That's all I got to share as far as today's session is concerned. I wanted to leave some space for question and answers. I don't know if I have time for that. If you do, I'd be happy to take a few questions. Do I have time for a few questions? Hello.
We'll check, Professor. If there are questions, we'll make the time.
Yeah, please. I'm done. I'm open to questions now. Please.
Sir, we have not received any questions, but if there are any questions, I request all participants to please post them.
Sure. Has such sham litigation been? Oh, I think this might be for.
That's for the other resource person, Professor.
Okay, sure, fair enough.
But thank you. Amazing session, very thought-provoking. It will time to formulate the questions on that, I'm sure. And if they do come.
Okay, there are a few questions that are coming up.
All right, great.
Okay, first question is, sir, isn't anchoring a heuristic aspect? Ashik, yes, anchoring is indeed a heuristic aspect, and heuristics play a role in how human beings make decisions. So therefore, yeah, whether it's a heuristic question or not in your language is a moot issue in my opinion. Actually, it is definitely a very interesting. It is a heuristic, yeah. There's a question from Sandeep. Is it fair to ask why economics is lagging behind environmental law, where market forces are not reflecting the real cost of fossil fuels, or market forces encouraging developing countries to dilute environmental laws for attracting foreign investment? I would actually argue with you, Sandeep. Yeah, I agree with you. Economics is see, one of the first things that you should know as an economist. I don't know why. I think one of the first things that a person should know as an economist is where markets actually don't work. I studied in Chicago. I studied in this holy city of Chicago. So therefore, I am supposed to believe in free markets. But I would actually argue with you that I don't necessarily agree with it. In arguments where there are externalities present, environment, free markets don't work. So that's why you have a completely different version of economics called environmental economics, which deals with those issues. Do I actually agree with you that economics completely fails as a subject when it comes to addressing environmental queries? I don't. I'm not an expert in environmental economics, to be honest, but there's a huge branch of literature out there which looks at the mechanism design aspect. How do you make a selfish individual work selflessly? That's the whole argument that I'd like to bring to the table. While I'm not an expert in that region, I can tell you that yes, markets do not work in some cases. And I would actually have to say that that in those cases, you need active involvement of a regulator. So the next question is, except for negotiations, do you think behavioral economics is applied elsewhere in the field of law? Of course, yes. It's not just negotiations that you're talking about. How do people react to laws being made? We talked about the 2% CSR law. How do companies respond to that law? Is a behavioral question. Anybody who thinks that it is a question of logic, of course, firms are going to give 2%. Well, they're mistaken. Firms give you 2%, but firms also manipulate on how they give the 2%. We're doing several set of case studies on this. Happy to share at a future time once the paper gets published, not now. But I am very clear. Amartya Singh asked a very interesting question. What is the superior way to analyze laws from the point of view of economics or psychology? Here is the deal, dude. You're not going to survive just because you eat protein. You're not going to survive just because you eat carbohydrates. You need both. Neither economists nor psychologists should ever be policymakers. The one who understands both should be the policymaker. In my opinion, both of them are needed. It's not one subject being better than the other. And I think one of the first things that I confess is that economists are taught to value everything. It's up to you to believe. I mean, can you value everything? Somebody pointed out to the example of fossil fuels. Can you value fossil fuels? I don't think so. I don't think the real cost of fossil fuels is ever possible to be estimated. In the world where there are externalities, it is almost impossible to estimate. So therefore, the argument here would go in several ways. It's both of them that I actually believe. And there's one more question that I actually see, and I think this will be the final question. We are all individuals who think of self-interest, a very classical economic concept. Therefore, the CSR behavior by firm is not morally justified, but on classical economics level, it does make sense, doesn't it? You know what? The reason why I think many of us have unearthed the reasons why firms do CSR is because it improves their perception amongst shareholders. Nike does CSR. Nike stopped sourcing shoes from Bangladesh after that famous Dhaka accident, or infamous Dhaka accident, is because shareholders are very angry about the lack of basic safety standards, not because maybe Nike cares. I don't know. Maybe it's wrong to say that Nike doesn't care, but Nike does care about what their shareholders think and what the investors and the buyers think. And if they don't, Adidas is going to steal a march over them by saying they care about the safety concerns of their manufacturing center. So that's where I do believe CSR is happening in a significant way in India. Is that the insignificant way all over the world? Is that the right thing to do? Is it the wrong thing to do? I'm going to leave it to you to figure out. I don't want to bring in models here. I'm an economist, for God's sake. Yeah, but that's the whole argument. I think it's a beautiful question that you're actually asking. The answer to that is very simple. Firms, in my opinion, firms do a lot of CSR because what is firms? Firm is nothing but an entity where shareholders are investing some amount of money. So firm as such has no conscience. Firm is a homo economicus entity. But firms therefore indulge in these homo sapien characteristics because they realize that being homo sapien is the best way to boost their profits. That's a very cynical way of looking at it. But then again, as I said, the disclaimer is I'm an economist. I'm allowed to be cynical. If I'm not cynical, who the hell is allowed to be cynical? Yep. Okay, that's where yeah, thank you very much for all the comments and questions. It's always, as usual, very interesting to talk at GNLU. I've given 3 or 4 talks already, and I really enjoyed each one of them. So thank you very much. Thanks, Professor Nagar, for inviting me. Thanks, Professor Thakkar, as well, for inviting me for this session.
Thank you for accepting, Professor. As always, it's been an amazing session. Thank you. Thank you.
Okay, can I log off?
Yes, Prof.
Thank you, sir. Rishi, over to you, please.
For the next session today, we have Mr. Lucas Bento with us, who is a consultant and business strategy lawyer with immense experience in corporate governance, corporate law, and commercial contracts. Mr. Bento works in strategic consultancy for new business development, as well as in dispute resolution, with experience in domestic and international arbitration. Having studied and practiced in the field of law and economics, he is here today with us to talk about why corporate law and economics. Over to you, sir.
Really, thank you for the kind introduction. I think I must start this presentation just with a kind and very warm thanks to my dear friend. Thank you for showing your face. Professor Renita Nagar it's more than a person that I admire deeply, but it's a friend that I'm very, very proud to call as friend. So here today, what I can say, Professor Nagar, I think 4 years after, I had the honor to be hosted at GNLU in person. So it's a little bit of shame that I'm doing it digitally today because I would love to have done it once again in presence to hug you and have amazing food. Yes, I'm a huge fan of Indian food. So, but today I was invited by my dear friend to talk on research in law and economics. As I was kindly introduced by your friend, I mostly work in corporate law and capital markets. So my address will be on how the development of the methodology of corporate law and economics has been over the years, and what do we expect for the next research proposals. First of all, I have to say that I'm not really keen on Cisco WebEx. So if I do make any mistakes, stop something, please let me know. I truly enjoyed, and that's something I must say to all the attendees. I don't know how, but this system is capable to tell me who is paying attention, who is not paying attention. That's some kind of shaming sanction, but it's funny to see. If you don't know, just look to the attendee list. They have some kind of exclamation point to those who are not paying attention. So just be aware of that. Jokes apart, let's try to talk a little bit about corporate law and economics. So talking about corporate law and economics goes back to understanding how law and economics has been developed in the US. Law and economics, as such a subject or discipline, was developed under the looks of economists to what are the matters of law that were somehow intricating the development. However, besides someone can say the founding father of law and economics was Professor Ronald Coase, one of the most common phrases used by Ronald Coase in all of his writings is lawyers know it's best. Lawyers know it's best. Lawyers know it's best. What he wanted to tell it all the time. What Professor Coase was doing is proposing to lawyers that they come to the debate and they join him. And that happened. How that happened? Mostly famous one was Professor Richard Posner and Judge Richard Posner. He was a justice of the Seventh Court of Appeal, if I'm not mistaken. However, other people joined the group. And then another very famous judge, one of the founding fathers of the field, decided to talk about corporate law. Back at that time, the structure of law and economics was pretty much economists doing modeling that should be applied to understand law, and lawyers trying to learn economic concepts to apply and understanding their own field. This is the very foundation of corporate law and economics. Professor Frank Easterbrook, together with Daniel Fisher, wrote the book, The Economic Structure of Corporate Law. What did they do? They pretty much got all the main subjects of corporate law and they tried to explain it economically. So if you go through the book summary, you're gonna see that pretty much it's exactly the same of a handbook of corporate law you have at school. So it goes first the corporate contract. Then it goes for corporate capital. Then it goes to every single same subject. The only difference, they try to teach the subject with a different language. What it tells us? It tells us that at the very beginning, when we look to corporate law or corporate law and economics, the idea is to teach corporate law, understanding the economic reasons why of it. Traditionally, we would teach corporate law, think about history. So for the most traditional corporate lawyers, they would tell you how corporate law has become to develop in Europe. They would tell the history about the mercantilism, how people in this Western world would go to the Eastern world, in fact, to India, to be really honest, to buy specialties and flavors and so on. And they would tell you the development of corporate law was divided in two big type of institutions. One mostly related to the south of Europe, especially Italy, because they would have small trades through the Channel of Suez and to arrive in India. So that needs lower amounts of money. So they could just get money inside of a family with a couple of friends, what nowadays we call friends, family, and fools, and do small trips. However, they could be a little bit dangerous, but they were way less dangerous because they were inside of the Mediterranean Sea and Suez Channel. So no strong water or big thunderstorms or so on. Those were what we what we nowadays would call partnerships. They would build the first business entities as partnerships for these trips to go to India through the Mediterranean Sea and Suez Channel. However, there was a monopoly of the Italians. There were more countries in Europe that wanted to go for these big adventures and trying to raise money for their mercantilism era, and they could not follow the same path. The path around was literally around Africa. But giving the whole travel around Africa demanded way more, demanded to take way more risks. Which type of risk? With stronger storms and very hard sea to pass through. Also, taking this kind of risks demanding a high, very high possibility of profits because you wouldn't take this kind of risk with small ships. Also because small ships wouldn't be strong enough to do this travel around. in order to fund these big ventures of big ships that would do big trips and try to make big profits, it wasn't enough to have the money of one person, one family, of a couple of friends and fools. And that's how became corporate law in such as corporation. In such as corporation, because here we are not talking about a couple of people that join together because they're friends or know each other. So the association of people were not because who they were. Here we are just talking about putting a bunch of money together so it could fund a venture, and everyone who puts money there would get money back if it was a successful trip. See, we have the first association of money, not people anymore. What matters here is how much money you bring to the table, not who you are. Once we say that, we create the first concept of corporation. So one thing that's very important when we study corporate law, it's we have to be very aware that there is a strong difference between legal entities when we're talking about partnerships, where people matter, when we talk about corporations, where the money matters, not the people who are behind that. And that the development of corporate law gives so. Trying to study corporate law in all the countries in the world in some kind of a big, strong comparison study, 5 professors in 2003, they took the challenge of describing the anatomy of corporate law. That resulted in this book called The Anatomy of Corporate Law. To talk about the anatomy of corporate law, the professors took the professors took some premises, which were, the first is, there is some kind of agreement that every country of the world regulates its business entities through corporations. Secondly, they said corporations have some kind of set of rules that gives them a talent identity, the economic reason, economic utility, why they serve for. So there are something in common between no matter the regulation you use that will define what is a corporation. Third, the loss of every corporate act around the world will try to deal with the possible conflict of interests between the ones who put the money and the ones who manage the money. Taking those premises, professors start to study their own corporate laws in each of their own country. And that's a very interesting research because this book started with, if I'm not mistaken, I cannot be because I'm looking to the book right now. It's 1, 2, 3, 4, 5, 6, 7 professors in the first edition. Then it became 9 professors in the second edition. And 11 in the third edition. What does book mean? And that's a very interesting thing. They have 3 editions of the book and they have the same amount of pages. It's quite amazing to really honest. But coming back to what this book means to us, they try to look in every single developed or in developing country in the world, what are the key features that would identify corporate law in all of them? Taking the premises that countries would organize their business entities through corporation, that corporations would have some economic utility, and that they would, the corporate acts would deal with conflicts of interest, they decided that the most important things to be described in any corporate law structure would be 5 features. The first of them, legal entity. The second, limit liability. The third, the capital should be represented, the invested capital should be represented with some kind of title bond that could be transaction between people. The third, they would be managed by something close to a board of directors. And the fourth. And the fifth would be the control of this business would be done by the ones who invest the biggest amount of capital. Understanding that, defined to us that the corporate law has, understanding that would tell to us that corporate law in every single country would have to deal with these features. However, there are more to corporate law than that. The German scholars, the most traditional ones, and here I'm talking about Herbert Wiedmann, Klaus Holt, they will define corporate law as the legal word that would describe the birth, the life, and the death of a corporation, both of its patrimony, its governance, sorry, governance, and, whoa, I messed up. Patrimony, governance, and corporation, sorry. What do they say with that? They would say that in 3 moments of the life of the corporation, so its birth, its continuity of life, and its death, the corporate law should deal with how the shareholders organize themselves, how they treat with each other, which is the corporation. The corporate law should deal with how the business entity, the corporation, would treat in the market, how it would be managed, how it would manifest its will. And thirdly, the corporate law should deal how we define what belongs to the corporation and how this patrimony should be liable or not. Lately, a very, very famous professor for Columbia Law School, Professor Zaha Goshen, together with another professor called Sharon Haynes, they wrote a paper called The Death of Corporate Law. When they told us the death of corporate law, they said, looking to US, that's very important premise here. They looked at the US and they said, nowadays, with shareholder activism, there are such a strong powers in role to regulate the corporations through corporate governance that corporate law does not matter anymore. They told us that Delaware courts of law have represented a very strong role in the development of corporate law through the years. However, nowadays, they are not that important anymore because as stronger the role of the shareholders are, weaker is the need of court of laws. As long as the shareholders can implement their activism and their fiscalization through the corporation, it won't be necessary to have the courts of law. The courts of law will stay there, as we call in law and economics, as a believable threat. So if someone tries to disrespect the rules of the game that gives the power to the shareholders to implement their activism, you would have a believable threat that could not be done. But what we need to guarantee is simply that the shareholders do their work. That's probably the most cogent argument someone can do, right? Because it's pretty much corporate law language to say, as long as the information, or better saying, as long as the transaction costs are very low, trending to zero, the players would set their arrangements in the most efficient way, regardless what the law has to say. So what do they say is we just need a believable threat that the shareholders can implement activism. I have a problem with that. Why do I have a problem with that? And that's why the name of this address was decided to be, and I have to tell, I kind of put the organizers here in a little bit of despair with me because I just sent the name of my address last night. So they were kind of, I would say, angry with me, and for that I'm sorry. But why I decided to say, why did I decide to call, better saying, this address, Why Corporate Law? Because what I come here is not just to disagree with Professor Goshen, which is a person that I admire the most, but to say that maybe the biggest mistake of corporate law and economics over the years has been that we look too much to the US. Why do I say that? US has a very unique feature when we deal about corporate law environment. When we talk about big corporations, US has a very dispersed market. Very, very dispersed market. When Berlemins wrote the book, The Private Property in the Modern Corporation, they defined 5 types of corporate control that could be implemented in a corporation. One of them was the majority control. The majority control for them was a possibility where someone would have 50 plus 1 of the shares of a corporation, and so it would have the majority of decisions in the general meeting. However, it was limited to exercising of voting rights in the general meeting. Because that's how they see corporations. That the shareholders should exercise their rights in the voting, in the general meeting. What was missing there? It's once again a believable threat analysis. Lately, Professor Gordon from Stanford University, he wrote a paper called The New Kids on the Block. And recently, it's maybe a too euphemistic approach of mine because that was written, I think, in 2017, if I'm not mistaken. But what were the new kids on the block? The new kids on the block, they were talking about the super, super big hedge funds. Why talking about super, super big hedge funds? Because the super, super big hedge funds, they have so much money that someone could consider that infinite. And then probably the economists are going crazy when someone says money is infinite. But for the matter here, we can consider that. Why? Because it's such a big amount of money that this fund has the capability to buy every single share available in the market of a given company. And why does that matter? That matters because when an institutional investor, as a hedge fund with this amount of money, comes to the table to talk with the management of a corporation and says, excuse me, but I would like to discuss with you your management decisions or probably a potential deal, why you're not taking care of it, whatever business judgment the management is doing. If the management strongly disagrees with this hedge fund, the hedge fund has the economic power to buy enough shares to fire the management. And then the whole protection of the market, that the company should be managed by a board of executives, board of directors, that this is different from the control of the shareholders, which exercise or declare control only on the general meeting, doesn't make sense anymore. Because the believable threat that I can fire you at any time make you comply with my will. And complying with my will looks strong when we talk about the US environment, because we're talking about those dispersed corporations, dispersed ownership corporations in the capital markets. However, for us in developing countries, that is the rule. And that is not the rule because we do have super big hedge funds that could buy the company, but because the companies are controlled from the very sense. What I mean by that is the dispersed ownership markets, they are a reality in US. And only there, maybe you can say about UK as well. They are not a reality in most of the countries. In most of the countries, companies are owned by families, which has a main person who control the corporation as its own. So the idea of separation between the property of the corporation and the property of the shareholders, which should be the shares, are not such strong as we have been believing to. A controlling shareholder in most of the countries of the world, it's also controlling the business of the company. That's funny. I'm from Brazil, for the ones who haven't noticed so far. In Brazil, that is so strong that in 1976, when the Corporation Act was written in Brazil, they put in the law the controlling shareholder as, and that's a very interesting way of approaching it, a chair. What I mean by that, don't you have the chairs at the executive board? Don't you have the chairs at the board of directors? Yes, that's what we did here in Brazil. We defined the controlling shareholder as the person who has the power to control the business of the company. There are a better way of doing that if you look into the law, but putting in a simple way. As the person with the capability of controlling the business of the company. And for this person, we gave not only the right to do so because we knew that economically would do it anyway, because he would just look to the CEO of the company and say, do it. And if the CEO don't do it, he would fire the CEO. So we just assigned the legal right to this person for simultaneously saying, as you have the right to do so, you have liabilities to be taken upon. Because you have the right, you have liabilities. You have responsibilities, or what we could barely translate in English saying fiduciary duties. However, besides this would be the reality, and totally not the legal ground, but the reality in most of the countries around the world, that you have corporations structure in a way that you do have an owner of everything. We are only talk about the big corporations. I can tell you at least since the 70s, we discovered that partnerships are so big of a risk to people to make investments on. Partnerships has no limit liability, more or less. You could have a limit liability partnership, you could have a limit liability company, and then you have to decide in a very, very big dogmatic discussion, is a limit liability company a corporation or a partnership? Structurally, partnerships shouldn't have limit liability. That should be the rule. However, another book to you, I like to show books as you have seen. Another book that I really, really recommend, it's called Limit Liability by Professor Todd Henderson and Stephen Bainbridge. They argue in this book that limit liability is probably the cleverest idea mankind has ever had. It's a funny because they give it as example that if you think energy, electric light, it's something clever, understand that was only possible because there were investors in limit liability, like holding limit liability. So they decided to invest that was possible to develop the electricity. Electricity, of course, not the physical means, but you know, the chaining of electricity for our houses. We discovered that we do need limit liability, which is a corporation feature to invest in small businesses. What we do say about the guy who owns a bakery on the corner, what we do say about the guy who's starting a startup or any kind of business. This guy needs investment. And sometimes, or most of the cases, every single investment in the very beginning is pretty much friends, family, and fools. as the partnerships were in the very beginning in Italy when I told you the history. However, some of them need more investments to grow. But one thing for any corporate lawyer that would face, it's how the heck, trying to use proper English here, uh, we're talking about giving a corporation to a person, but every single time this person goes looking for investment, the investor says, I need your skin on the game. I need you to have a cap table that you are fully invested in and you take risks personally. You have to own the business. So, limit liability is a feature demanded by the market to have investments. At the same time, it's a feature which the investors itself wouldn't like to the ones who really do the business to have. And then you tell me, Lucas, aren't you telling me that all managers then should be liable for their acts? They are. They have fiduciary duties to it. The ones who don't are the controlling shareholders. The controlling shareholders are the ones with the capability to truly manage the company through believable threats. At the same time, they have their liability limited according to the need of corporate law to have it. I'm not the first crazy person to think it. To be really honest, Professor Lucan Hickes, which is one of the writers of the Anatomy of Corporate Law, has in 2019 wrote a paper called the extended liability to systematically important financial institutions. What he proposed is to extend the liability of the controlling shareholders in systematically important financial institutions, because if a systematically important, which means a financial institution that has so much money or so much capital invested that could put the financial market um, into danger, let's use as a general word, these controlling shareholders could not taking profits out of putting the market in danger. And the way of doing it is extending the liability so they take higher risks. And in order the risk they're taking too, they at the same time will be more conservative and more compliant to avoid those risks to perform and they lose their money. So you put their skin on the game. So when I defend corporate law here, it's not about corporate governance in the sense of just bringing shareholders to the table, because that's beautiful. If we are talking about a true corporation, a big dispersed company in capital markets where no one holds a big stock of stocks, but just institutional investors and maybe some retail investors that would be active. That's a very beautiful modeling discourse. But that's not the real speech. That's not a speech of truth. It's not that that doesn't exist. That does exist in cases of US or UK. For us, we are looking to another level. We are looking to corporations who are truly owned by someone. And then here I will do some self-propaganda, which I do think it's quite moral, to be really honest, but I will do it anyway. On my PhD thesis, which should be published next year, I defend the name for controlling shareholders, which are controlling more than just by majority controlling, as explained by Berlemins, but the ones who truly own the company. I call them totalitarian shareholders. And I have also to say that that name is not mine. That name was written by an old professor in Brazil back in the 70s also. But it's a very clever name to understand. When we are talking about totalitarian shareholders, we are talking about a shareholder which corporate governance is not able to fight against him because of the amount of shares or the structure of the bylaws that allows him to control literally the business of the company. We are talking about a shareholder who has so much importance in the market that most likely self-regulation authorities and regulation authorities has a strong reasons to be suspiciously captured by them. I have explanations to that. If you go through the papers I have published, you're gonna see when we talk about corporation, like the self-regulation of the market is usually done by the stock exchange institutions itself, and their performance depends on the performance of the companies listed into those. So that's why they have a conflict of interest on trying to uh, enforce their self-regulation. If you go for regulation authorities, you have the what we call you have this competition between professionals, between the regulation authority and the industry and the market. As so you all the members, the professionals who are working at the regulation authorities, they can get offers from the market and they will probably make more money and in the industry. So they have this, let's say, sympathy to the industry that makes them a little bit more lenient into enforcement. And then there is one branch that cannot be captured because at the end of the day, they cannot go to industry or they're not supposed to go to industry, which are the courts of law, the judiciary, the ones who define corporate law. The thing is, in developing countries where we have controlling shareholders, or better saying, totalitarian shareholders, we cannot declare the death of corporate law. The court of laws cannot be just a believable threat that would be there. They are the ones playing the game, because if they are not, then we just leave the corporations to be partnerships owned by the controlling shareholders and with minority shareholders 100% kidnapped to their investment. That's what I have to say. I really thanks the opportunity to stay here, and I'm open to any kind of questions. Once again, thanking personally my dear Professor Renita Nadar, great friend.
Thank you, Professor Lucas. Shubhi, do we have questions?
Surely, I'm totally open for that.
No, ma'am, I don't see any questions as of now, but if anyone has any questions, please, I request them to post it.
Should I look to the chat or to the Q&A?
So in the last round, also the questions, I think there's some time lag. The questions came a little late. So maybe we'll just wait for a minute or so.
It's okay. How's the weather in Ganaga?
Last 2 days have been excruciatingly warm. It's supposed to be raining, but we haven't had rains in Gujarat, proper rains, but a large part of India is flooded if you just follow the news.
Yes.
So this area we are waiting rains, but it has been very, very warm, last two,
Yes,
3
I
days in
remember.
particular. Yeah, you remember.
Yes, I do remember how warm it was back in 2017, 17, right?
17.
18, 17,
17.
yes.
We had the banking
Yeah.
conferences.
Yes.
And Chicago was 2015. Long time, isn't it? Really long time.
Very long time. Time has passed, Anita, and you're still the same, beautiful as always.
How's your health and all right?
Thanks the Lord, I could keep myself quite healthy through this whole pandemic of the world. I've been taking the vaccines already, thanks the Lord. So yes, I tried to hide myself as much as I could at home. Just waited until it passes. Hopefully it will be soon.
Yeah. Okay,
I
so
do think we have questions.
we don't have questions. If they do come, we'll mail them to you. And on that note,
I
Ma'am, I've
think
just received one, sorry to interrupt you, ma'am, but I've just received one question from
yeah,
Mr.
please,
Sandeep.
please.
And that is your comment on superstar founders influencing share values and undermining other shareholders.
Let me see if I understand. So, how do I see the role of founders increasing share value and undermining other shareholders?
Tesla, for example, that's what he has written.
Is it on, sorry, on chat or Q&A?
And another one that I got just now is, sir, can shareholder activism lead to better environment-related decision by corporations?
Okay, so we'll do the second one, then I found the first one to answer.
Okay.
So the second one, shareholder activism can improve the corporate market. Yes, they can. I do believe in shareholder activism and probably one of the biggest defense of corporate governance as such. I do believe, and that is a belief I share with some professors around the world, that corporate governance it's probably the most important role to really, really bring nations out of poverty. Why such a strong statement? The thing is, corporate governance is the one feature that allows investor to believe in investments. And when you believe in investments, you can take out your money from these very traditional big companies and big banks and go for ventures and go for developing of new ideas. And every time you put a new idea on the market, every time you put a new um, service, a new product on the market, it's when you are enriching literally our economy. So it's called real economy. You create a new product, you add new value. You are not just substituting things on the market. You are really creating new things and adding new value. In corporate governance, it's what allows what Professor Schaffer and Professor Kuter called the double trust dilemma to be solved. The double trust dilemma is possibility of having new ideas funded by proper capital. Shareholder activism is the feature, and that I agree with Professor Zahagoshin, that makes the investments more attractive to investors and so more able to develop new economy or real economy. However, I do not believe that the role of court of law can be diminished or undermined in that situation. That's my point here. Why? Because in most of the cases, and that's my biggest issue here, most of the cases, when we look to corporate law, we are looking to corporate law from the glasses of a big lawyer in a big law firm looking to a big corporation. And the majority of the cases are not so. When we talk about real investment, it's not about putting money on Apple, or at least not on Apple nowadays. It's about putting the money on the next Apple. And nowadays, the next Apple, it's probably a small, rather small partnership owned by one or two guys who the market doesn't know. And in order to the market to know, this company needs investment. And this company will only get investment if we allow this company to give trust to the investors. When we're talking about those small companies, when we're talking about this type of investments, we have a big, strong problem of putting money for a small part, for a small percentages that put you in this kidnapping situation to the controlling shareholder. That's why you don't buy shares of the bakery at the corner of your house. Because it doesn't make sense, because the baker will pretty much own the business and you don't know if it's going to be properly managed. And unfortunately, the corporate governance tools, which are designed to be corporations, are not effective in those situations. And those situations are the majority, those situations are the real rule, and those situations are ruled by corporate law. That's why corporate law is not that. It's just not being used to big corporations in the US, but it's used to the majority of companies around the world, which are closer to the bakery at the corner than Apple. Sir, can you please tell me about the role of the judiciary and courts with respect to the last point of discussion? I think when I told the court of law are the last resource, the last gatekeeper here. Probably you have heard this expression before, gatekeeper. That was written by John Coffey in probably one of the most famous books in the history of capital markets law, business law, and whatsoever. That's what I do believe. I do believe as the judiciary plays the role of a gatekeeper. As any investor, you have the asset manager, you have the fiduciary agent, you have the trust, and those are supposed the coordinator of IPO or any kind of offer. Those guys are supposed to be gatekeepers and taking care of regulations in a specific sense. That's what I believe about the judiciary. I think the judiciary is more than a threat. It's a truly gatekeeper for the majority of the cases when we're talking about company law. I do believe the judiciary deals with the beautiful, sophisticated tools of corporate governance, creates for the big and dispersed ownership companies. Corporate law is what creates it for the everyday type of investment. And that's what's the relevance of the courts. A professor in Brazil, Professor Paulo Forgione, once told me, we're in a discussion about arbitration. What's the role of arbitration? Why arbitration is so important? And she told me that arbitration is the birthplace of complex contracts. Normal discussions should go to the judiciary. She used to say that in a countryside judge, it's a super expert in stealing chicken problems. So if a guy stole a chicken from another person, an arbitrator in a fence arbitration chamber in London, US, has no idea what are the problems of stealing a chicken or how to prove if the chicken was stolen or not. So what I'm trying to praise here is pretty much corporate governance. It's super sophisticated tools which are very strongly applicable to those beautiful companies and corporations and the stock exchange market in US. However, for us who deals with every single type of company in developing countries which dispersed ownership, it's not true. Even if it's a big corporation, a strong corporation, oil company, it's strongly owned by one person, one family. Those big fence tools are not as strong as we believe. And for that, we do need statutory regulation and the court of law.
So we also have one more question for you. That is, internet has led to the development of new forms of corporate structures, such as decentralized autonomous organizations. How do you see corporate governance developing in future?
That's a very interesting question. Professor Klaus Haupt from Germany, he writes that corporation is just one way of organizing business. You can have infinite ones that you can create through contracts, through, in fact, any kind of contract agreement that would put people together to execute an economic purpose, could be somehow an association phenomena, and an association phenomena is the key fundamental of corporate law or any kind of business association, business entities, or company law as so. And here is important to us because that's something that people, and I would think UK people do it better than in US. We study so much corporate law as the only way of business entity, and we should broaden this name a little bit to company law, because once you understand company as more ways of association, business entity, that's only corporation. Internet is probably one thing that in every single discussion nowadays we should consider. I do believe that regulation through internet, and I would say not really internet as so, but through data control, it's something that coming to hand. I was talking to a friend back in Chicago and who works with the stock exchange market there. Uh, and he was saying that there's a very, very long time that he does not execute an order of buying. He works with commodities himself. Because nowadays he cannot follow the information. The information comes in a so fast way and so much analyzed and pretty much mined by his computers who decides to buy or not to buy, that in the end of the day he follows the orders after they are done by his own computer. He doesn't execute the orders anymore. He just looks at the order and see what happened, not what he will do. He said he started his career doing things. Now he just review things. Uh, that's what I do believe here for the evolution of corporate law. Of course, there are things that maybe computers are not able to grasp in a such easy sense. However, what we call RegTech, so the technological regulation, it's probably what we have as the most advanced tools for corporate governance. It's the ones which will not decide upon uh, how to regulate, but it will decide upon where to look at, where are the red flags. And the easiest way of doing so, if you think about a market where you have this bunch of computers deciding to buy or not to buy something, you have a regulation by the market itself because the computers stop buying a share. There is a reason why this share is not valuable anymore. And it's a regulation by technology itself, because so if you have no demand for the shares, the offer is still out there, the shares price goes down, the management board starts to think what is happening, and I have to react to that. I have to convince literally computers that I have value. So the role and development of corporate law is the regulations come from the stimulus that I give to the management board by using this information structure, purchases, analysis of data, and purchases of the stock in the market. I don't know if there are any further questions.
No, sir. I don't think there are any questions.
Okay.
Yes.
Please continue. Sorry.
No, sir. I was just checking if there are any questions.
Okay. So if there are no further questions, I think I'm 11 minutes over my time either way. So I would like once again to thank for hosting me here at this workshop. And I especially thank once again, because I will thank my whole life, because it's probably one of the best friends I've ever made and one of my dearest persons that I admire so, to Professor Renita Nagar. It was a pleasure once again, Professor Renita, to address your students and colleagues. Please count on me anytime I may be helpful, and I hope to have you here in Brazil as soon as COVID allows.
Thank you, Professor Lucas. Take care and be safe. Thank you.
Thank you.
Thank you, sir. Over to you, Kushi. We're joined by Marisport, sir.
So I would like to welcome you all to the last session for day one. Now we have Dr. A. Marisport, who is an assistant professor of law at Gujarat National Law University. His areas of research interest include mediation, international commercial arbitration, and criminology. He has an array of publications and papers in this area, while also chairing several capacity building sessions on the topics of dispute resolution and criminology. Today, before us, he'll be dealing with the economics of crime. Thank you so much for being here today, sir, and over to you.
There seems to be some technical problem, so I request the participants to please wait for some time. Thank you.
Hello. Hello.
Hello, sir. We can hear you.
Okay. Okay, ma'am. Thank you, ma'am. Actually,
Yes.
that attendee to panel, right? So that's an issue here, ma'am.
No
So,
problem. No problem.
okay. Just shall I share my screen now?
Yes. Yes, sir. Please.
Okay.
Participants, it seems that we're not being able to rectify the technical problem. So therefore, we will not, we'll not wait any further. It's already 7:20. We will reschedule this session mostly. It's a long day for all of you also, and there's uncertainty. So I would say that waiting would not be efficient. So we will reschedule Professor Marisa's important session. Please, we regret this technical disruption. But Khushi, I think we can, Khushi and Shubhi, I think we can, conclude for the day.
Yeah, ma'am. So I would like to thank all the attendees today for being here and all the esteemed panelists for the wonderful and productive sessions. And I hope that we can see you all tomorrow for day 2 of the workshop. Thank you so much.
Thank you, Shubhi and Khushi and participants. Professor Lucas, you're still with us. So thank you and see you. Participants, see you tomorrow. Thank you. Bye-bye. Have a nice day.
Thank you, Professor Anita. Have a nice night.
Thank you, ma'am.